my computer going. We're here on State versus Jeffrey Hall. The file number is 25 CR 08187. Mr. Hall is here out of custody with his counsel, Ms. Long. Mr. Dietrich's here for the state. We're here for trial. Is the state ready? Yes. Defense ready?
Yes.
So, looks like we've sorted through our techie issues. Everyone has their seating chart with the first randomly drawn 12 numbers already in there. And then if we have challenges to those seats, we will pull from the list, which means juror 359 would be the next juror to fill a seat up in the box.
Yep.
Okay. So anything before we get going? No? Okay, let's go ahead and get our jurors. Go ahead and get yours. Yeah.
I'm sorry, I didn't hear you say that.
Yep, let's get yours.
Thank you. We have to use mics today.
If you want to make an appellate record. Yep.
Okay.
It's really bad otherwise.
Okay.
I know it's a pain to use those mics, but it's either that or stay in your seat. So, using those mics. And Mr. Hall, at some point I'm going to introduce you and have you and your lawyer, if you could stand at that point and look toward the back, because the people in the back are just going to see the back of your head. Because there'll be lots of jurors back there. So at that point, if you, Ms. Long's going to stand up, if you could stand up too and kind of do a swirl. Okay.
It's just so that people can have a look at you, because the judge is going to ask
If anyone knows you.
If anyone knows you or me or
Yeah.
Mr. Dietrich.
So I guess there was a juror who was late that's not on the list, so we'll just put him at the end. It's juror 356. Perfect, yeah. We need, that chair should be juror 106. Yep. Okay. Right, I just put them on the end. Good morning, everyone. How many people would like an assisted hearing device? How many people would like a headset? They're wireless, they work great. Anybody? Okay, one in the box. Anyone else? No? If it turns out over the course of the proceeding that you think, wow, maybe I should have taken her up on it, let me know. Is that helping you, ma'am? Okay, now that you're all comfortably seated, please stand back up and raise your right hands.
Do you and each of you solemnly swear that a true answer you will give to all questions asked by court or counsel touching upon your qualifications to sit as a juror in this cause, so help you God?
Thank you, everybody. Go ahead and be seated. First, I want to apologize for the delay. There's anticipated that there might be some videos in this case. Our tech system, of course, decided to go on the blink overnight, so that's what we were doing, was fixing the tech system, so I'm sorry you were stuck waiting while we were doing that. But we are now ready to get going. So if you have like a laptop or a phone or something, please turn it off or put it on mute. So we've drawn, number one, you're all numbers. That's for your safety, so hopefully everyone knows their number. It's been a busy month. The 12 people up here, the computer drew their numbers randomly. So if anyone up here is excused, we will pick the next number on the list. Just as a heads up, the next number on the list is juror 359. Do I have a juror 53, 50? Okay, so you're next up, and you'll just go up to whatever seat up there is vacated is the process we're going to be using. Okay, ladies and gentlemen, today we are selecting a trial jury for the criminal case of State of Oregon versus Jeffrey L. Hall. State is represented by Chief Deputy District Attorney Jeremy Dietrich.
Good morning, everyone.
And is the person coming in a juror or not? Okay. And Mr. Hall is represented by Attorney Kayla Long.
Good morning.
Yes, they are. Your Honor, he is a juror.
Okay, did we have a juror that just came in? Yes? Okay, can you stand up and raise your right hand and the clerk will swear you in? You missed the group.
I think the gentleman just walked out.
Is he a juror as well, the gentleman you were with? No, just you?
He's my caretaker. I have seizures.
Okay, you can just actually, I'm sorry to say it, do you feel comfortable staying or would you like to go? I don't want you to have a seizure.
I don't like having him in public.
No, I don't want you to. Why don't you go ahead and go? I'm sorry to make you come all the way in. Okay, thank you, ma'am. Defendant is charged with the offense alleged to have been committed as follows. Interfering with the peace officer alleged to have been committed as follows. Defendant, on or about September 13th of 2024, Tillamook County, Oregon, did unlawfully, knowingly refuse to obey a lawful order of Deputy Patterson, a person known by the defendant to be a peace officer. That order was to move to a safer location during a bank robbery. To this offense, the defendant has entered a plea of not guilty. A plea of not guilty denies that the defendant is guilty of this offense. Under our system of justice, the defendant is innocent of any crime or wrongdoing unless and until the state proves the defendant's guilt beyond a reasonable doubt. Therefore, the burden is on the state to prove the defendant's guilt beyond a reasonable doubt. The state has the burden of proof on these facts. Under our system of justice, these facts are deemed not to exist unless and until the state proves them beyond a reasonable doubt. Some of you may have served as jurors in civil cases where lesser standards of proof apply. For example, proof by a preponderance of the evidence or proof by clear and convincing evidence. In criminal cases, however, the state's proof must be more convincing. It must be beyond a reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt means an honest uncertainty as to the guilt of the defendant. As a juror, you must return a verdict of not guilty if, after careful and impartial consideration of all the evidence in the case, you are not convinced to a moral certainty that the defendant is guilty. Each juror must be able to judge this case fairly and objectively. Therefore, if any juror knows of or has any association with any of the parties, lawyers, or witnesses, or if any juror has any knowledge of or has formed any opinion about this case, this should be brought to the court's attention. So I have a series of questions for all jurors in the room, and then I'll have a separate series for the people who are up in the box. So first general question, all jurors, do any of you know Mr. Hall or either of the lawyers? If so, please raise your hand. Thank you. All righty. So juror 106, who do you know?
Mr. Dietrich and Ms. Long.
Okay. Without saying anything more, could you be fair and impartial or not? Thank you. Anyone else in the box know Mr. Hall or the lawyers? Out here, hands for people who know the lawyers or Mr. Hall. Anybody? All righty. Next, the following people may be called as witnesses. If you know them, please raise your hand. Deputy Travis Patterson with the Sheriff's Office, Sergeant Troy Jackson with the Sheriff's Office, Trooper Jace Hughesby with the State Police, and Patricia Archambault. Anyone know these people? Please raise your hand in the box. Who do you know?
Sergeant Jackson.
Without any information, just yes or no, could you be fair and impartial if he's a witness? Okay, anybody else in the box? Hands this side of the courtroom. Ma'am, your juror number? 22. Who do you know?
Jackson, Patterson, and Dietrich.
Okay. Yes, just a yes or no. Could you be fair and impartial if you know 3 of the witnesses?
Yes.
Thank you. Anyone else? On this side? This side. Hands. Anyone new potential witnesses? Anybody? Your number, ma'am?
158.
Who do you know? Without any information, could you be fair if he's a witness?
Yes.
Thank you. Anybody else that I missed? As jurors, you are being asked to make very important decisions in this case. You must not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision-making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Your verdict must be based solely on the evidence presented. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by bias for or against any party or witness. So next question, all jurors, do any of you feel that your personal views concerning this type of case or the parties involved might affect your ability to be fair and impartial? If so, please raise your hand. That's based on the nature of the charge. It's a single count of interfering with a peace officer. Does anyone think I can't be fair with that charge or because of the people here in the courtroom? Anybody? Okay. Next general question, all jurors. This is set as a 2-day trial. We may be done today. It's hard to know. Like this morning we got high-centered for an hour with the tech issue. So we may be done today, in which case I'd anticipate we might be feeding you pizza and going into the early evening, or it might go into tomorrow. So is it an undue hardship for anyone to sit as a juror in that situation? So if you are excused for tomorrow, I don't know that. So please let me know. Undue hardship is like you worked all last night and you're still here. You have the flu, other illness that you can't sit, significant caregiving responsibility nobody can assist you for. You have a college exam. Those are just some examples. Significant work problem that nobody can cover for you, those kind of things. So is anyone up in the box an undue hardship to sit today and tomorrow? Anybody? Okay, let me start in the back. The juror 57, could you tell me about that?
Yes, I have 2 days of training in Salem. I requested the days off. That is,
Does it start tomorrow?
starts tomorrow morning at 9 o'clock.
Okay, and that's not something that they have training every week or something, I assume? Okay,
It's required for my job.
all right. You can go ahead and go, sir. We have quite a few people this morning. Thank you. So juror 359, come on up. Juror 359, come on up. Yes, sir.
Mine's medical. I have a chest cold, and with my asthma, I need to go to the doctor still.
Okay, you're free to go. Thank you. Okay, next person the computer picked was 357. Okay, anyone else in the box an undue hardship? Oh, sorry, make you trot all the way up there. There's usually a hot seat. Can you tell me about your conflict?
I have scheduled travel tomorrow back to see my family in the Midwest.
Okay, you're good to go. Thank you. Let's see. 93. Did you have your hand up for hardship? Okay, perfect. Come on up. Just a sec, ma'am. Go ahead. No, just a sec. Yes, can you tell me juror 370? Can you,
I'm on a waiting list for back surgery, so sitting all day is kind of hard on me.
okay, is it something that you, if you stood up and stretched once in a while or took some ibuprofen, or is it worse than that? I don't want you to sit.
Yeah, I mean, I really should have already had this done, but because I didn't have insurance.
Okay, so you'd be in pain for 2 days is what you're telling me. You're good to go. Thank you. 370. Juror 329, did you have your hand up for hardship? Okay, come on up then. Sorry about the mics. Okay, other people in the box, anybody? Okay, this side of the room, hands raised, people that would be a hardship to be here as a juror. Anybody? This side of the room, hands for anyone for hardship. And I do want to thank you all. It's been a really busy month. It's been a few years since we've had as many jury trials scheduled as we have this month. I don't know why it's a hot month, but it is. So I want to thank you for your service all month and coming in. Okay. I now have a series of questions for those of you in the box, and if you've done this a few times, you'll get the gist as we go. So juror 13, what part of the county do you live in? And who lives in your home with you, the relationship of the person? What is your occupation?
Supply chain manager.
Have you ever been convicted of a crime? What are your hobbies and interests?
Spending money.
The economy thanks you. All right. Do you have any close friends or relatives in law enforcement?
My nephew and my uncle.
Do you have any prior jury service?
Yes.
Were you around this month already?
Yes.
Okay.
I wasn't on this month. You excused me 2 times.
Okay. And I should say, I swear everyone in this room looks familiar. I'm getting really bad at remembering why, if you actually sat through a trial, if I excused you, so I apologize if don't take it personally if I can't remember. So when did you sit on a jury?
It was about maybe 18 years ago.
Okay.
It was criminal.
And did it reach a verdict without telling me what it was?
It did.
Perfect. Thank you. Juror 97, what part of the county do you live in?
Home.
And who lives in your home with you?
Son and children.
What is your occupation?
Marketing finance.
Do you have you ever been convicted of a crime? What are your hobbies and interests?
Sports, outdoors, kids.
Do you have any close friends or relatives in law enforcement?
A prayer neighbor.
How about prior jury service?
Yes.
This time?
This month.
Okay. And I think we've had a number of trials, none of which have had a verdict. How about other than that?
Yes, over 10 years ago.
Okay. Was it criminal or civil?
Criminal.
And don't tell me the verdict, but did you reach one? Okay, thank you. Juror 87, what part of the county do you live in? And who lives in your home with you?
My wife and my daughter
What is your occupation?
retired from the electrician in a glass plant in Michigan.
Have you ever been convicted of a crime?
No.
What are your hobbies and interests?
Genealogy, yard work.
Do you have any close friends or relatives that are in law enforcement?
No.
How about prior jury service? Have you served?
No.
Okay, thank you. Juror 99, what part of the county do you live in? And who lives in your home with you? What is your occupation? Have you ever been convicted of a crime? What are your hobbies and interests? Do you have any close friends or relatives in law enforcement? How about prior jury service? Not this month either? Okay, thank you. 30, what part of the county do you live in, sir? And who lives in your home with you? What is your occupation? Have you ever been convicted of a crime? No. What are your hobbies and interests? Don't really have. Okay, driving trucks? Maybe not. Close friends or relatives in law enforcement? No. How about prior jury service? Have you served before? Thank you. Juror 359, what part of the county do you live in? And who lives in your home with you? What is your occupation? Have you ever been convicted of a crime? What are your hobbies and interests?
Hiking, arts, and
Do you have any close friends or relatives in law enforcement? How about prior jury service? This month, other than that?
more than 3 years ago. I don't remember if it was criminal or civil.
Perfect, thank you. Juror 106, what part of the county do you live in?
Wilson River.
And who lives in your home with you? What is your occupation?
I'm retired, BLM, field manager, Corps, and then I served as the county veterans service officer.
Have you ever been convicted of a crime? What are your hobbies and interests?
Hiking, camping, hunting.
Do you have any close friends or relatives in law enforcement? How about prior jury service? About how long ago?
About 25 years ago.
Do you recall civil or criminal? And did it reach a verdict? Thank you. Juror 93, what part of the county do you live in?
Pleasant Valley.
And who lives in your home with you?
My wife,
What is your occupation?
dental assistant,
Have you ever been convicted of a crime? What are your hobbies and interests?
hiking, cooking, pottery.
Do you have any close friends or relatives in law enforcement? How about prior jury service? Have you served before? Okay, thank you. Juror 329, what part of the county do you live in? And who lives in your home with you?
Just my wife.
What is your occupation?
Project manager, estimator, for heavy civil construction.
Have you ever been convicted of a crime?
No.
Hobbies and interests?
Hunting, fishing, motorcycle.
Any close friends or relatives in law enforcement? How about prior jury service?
None.
Thank you. Juror 334, what part of the county do you live in? And who lives in your home with you? What is your occupation?
Disability, disabled.
Were you able to work at some point?
Yes.
What line of work were you in, sir?
I was a chef.
Okay. Have you ever been convicted of a crime?
Yes, ma'am.
Are you comfortable saying it out loud?
Yes.
What was it?
I have now brought 5 possession felonies.
Okay. How long ago, sir?
28 years ago.
Okay. When you're a wee bit younger?
A little bit, yeah.
Yeah. What are your hobbies and interests?
Hiking, camping,
Do you have any close friends or relatives in law enforcement?
my cousin.
Okay. And have you served as a juror before? Okay. Thank you. Juror 306, what part of the county do you live in? And who lives in your home with you?
My wife and my granddaughter.
What is your occupation?
I'm retired aviation.
Have you ever been convicted of a crime? What are your hobbies and interests?
Flying and carrying.
It's an interesting combination. Close friends or relatives in law enforcement?
I have had family members years past, and I'm going to deceased. I had some friends from various veterans groups.
Mm-hmm.
Very close.
More like acquaintances and,
Yeah.
okay. Prior jury service, have you served before? Thank you. Juror 154, what part of the county do you live in? Okay, so you're not a resident of Tillamook County? Okay, so you're not eligible to serve as a juror then? I think you have to be a resident. I'll talk to the girls out front, but you're good to go. Thank you. I'll educate somebody about that. Thank you for coming in. Okay, the next one on my list is 117. Who's 117? Did you have your hand up for a hardship or not? Okay, come on up. All righty, what part of the county do you live in?
Fairview.
And who lives in your home with you?
Chelsea.
What is your occupation?
I'm a sleep here.
Have you ever been convicted of a crime? What are your hobbies and interests?
I love music, movies, almost anything.
Do you have any close friends or relatives in law enforcement? And how about prior jury service? Have you served before?
Just this month, assistance.
Okay, thank you. The lawyers will now ask each of you questions. The purpose of these questions is not to argue the case or to embarrass you, but rather to determine your qualifications to serve in this specific trial. Please respond to the lawyer's questions honestly and sincerely. If you do not understand a question, please ask the lawyer to restate it for you. Before we get going, has anyone had way too much coffee and needs a break before we get going? Anybody? I see some hands. Anyone? Yes? Okay. So we lose lots of jurors. Please keep coming back, but you don't have to sit in your exact place on the benches. You do need to sit in your seat because we have a chart. So let's take 10 minutes, use the restroom. We'll come back and we'll start questioning. So thank you for your patience. Okay. Ms. Long, go ahead.
Thank you. Am I on? Counsel, ladies and gentlemen of the jury, good morning. First of all, I have to ask you to everybody, was anybody working downtown September 13th of 2024 in downtown Tillamook? Was anybody downtown when there was a bank robbery? Oh, I'm sorry. When there was a bank robbery in progress at the Wells Fargo? Yes, and your juror number? 304. And were you, did you witness anything that happened? Yes?
Yeah, I was in my vehicle, so I was heading west and the Chevron was on my right when it started to happen. So when all the law enforcement officers were getting there, I saw them getting out with their guns and then
Okay, I just want you to just stop right there. I would ask that.
Sounds like not a great trial for you.
Yes.
You're good to go home.
Okay.
Thank you.
And I just want to make it really clear, my client is not charged with bank robbery. But what happens surrounding this there's a bank robbery in the periphery, okay? So that's why I'm asking. Anybody else? Yes?
Well, I just drove through what was going on, but I wasn't walking.
Did you see anything that was going on?
It just looked like people were standing around and not really doing a lot.
So nothing more than people standing around?
Just moving around. Yeah, it didn't look like,
So how long do you think you saw what was happening?
not more than like a few minutes, like 10 minutes.
10 minutes?
10 minutes.
I think it might not be a good case. You never know. I don't want you to get in the middle and it turns out something you personally saw turned out to be significant. So you can put those on the chair. Thank you. And just a minute, I need to replace that seat.
Thank you.
Thank you. Have a good day. So I think we're up to juror 38. Juror 38. Okay, no juror 38. How about juror 95? 95? Did you have your hand up for hardship or not, sir? No. Okay, come on up, please. Okay. What part of the county do you live in, sir? And who lives in your home with you? What is your occupation? What line of work were you in? Have you ever been convicted of a crime? Yes. Are you comfortable saying it out loud? Yes. What was it? Last year, huh? All right. Hobbies and interests. Good place to live, need charge for that. Close friends or relatives in law enforcement? No. How about prior jury service? No. Okay, thank you. Ms. Long.
Thank you.
And minor possession probably actually wasn't a crime, but thank you for disclosing it. It might have been a violation.
Anybody else have any memory of being downtown Tillamook when there was a bank robbery in progress? I just ask this because I don't want anybody to get picked for this jury and then you hear evidence and be like, oh, I was there. I saw that, and I remember things differently. Does that make sense? Because when you're picked on the jury, you have to make your decision from everything that you hear from the witness stand. So it's really important that you don't have outside information. I mean, you guys have all been in doing this for a month now. Sounds like most of you have prior jury experience. So anybody else remember, I know it's quite a while ago, September of 2024. If you were downtown, saw a bunch of cops. No? Are we good? Okay. Who here has, well, let me back up. Juror 97, your neighbor, your previous neighbor was in law enforcement?
Yeah.
And are here in Tillamook County?
Yes.
And with what division? Sheriff, city?
ODFW.
Okay, so in Fish and Wildlife? And are you close friends?
My husband and him are pretty close still.
Okay, anything about that relationship that would make you be fair? Or because, I mean, basically, the bulk of the state's evidence is going to be from law enforcement. Does anybody here think that law enforcement testimony carries more weight than somebody else's testimony? Sorry, I see you looking up, thinking about that.
I mean, I wouldn't think so, but I mean, they are police officers, so.
All right, a sworn peace officer. What does that mean to you? If somebody's a sworn peace officer?
They would have potentially education and training on the, that will revolve around keeping the peace and how to, interact around keeping the public safe.
Right? Protect and serve. We all agree with that? Is that what our law enforcement officers are to do? Right? Keep the peace. Maybe de-escalate situations. Okay? Maybe, protect and serve their constituents. Right? Maybe not get everything riled up and out of control. Okay? How many people here think that citizens have a right to disagree with law enforcement actions? Yes, sir?
I agree.
Okay. Yeah? Okay. Okay. Yeah? See hands? See hands? And we have a right to maybe film what's going on our phones? Okay? Okay, that just means. Okay, I mean, we don't want to go too crazy, but we do have rights as civilians, don't we? Yeah. And when we come to our law enforcement, don't we expect them? Well, we have high expectations for our law enforcement, correct? Because they're the ones in the uniform, right? Now, how many of you, and I took notes, but maybe not the best notes. This has been a weird month for jury trials. Chief Deputy Dietrich and I can attest to that. How many of you have been on a jury this month? Okay. Okay, we got lots of hands. And neither reached a verdict, correct? Okay. How did you, was that the first time that you were picked to be on a jury? Okay, your prior jury experience, was it criminal or civil?
I don't remember. It was at least 10 years
Okay, were you making a decision about money or about guilt or not guilty? Do you recall? Okay. 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 And what about you? Have you had a prior jury experience besides this month?
Yeah, it was criminal, and the verdict was reached.
Okay. And did you enjoy that experience?
It was pretty heavy.
Okay.
It was a heavy criminal case. So.
Okay. And during that time, when you were on that jury, what did you expect the defense counsel, the person like me, what did you expect defense counsel to do?
I expected to be presented evidence.
Okay, so
I mean, because the defense, the goal is to create uncertainty, right?
okay.
So I just expect defense to offer as much evidence as possible.
Okay. And how many of you here expect me as defense counsel to present evidence? Okay. Show of hands. Did I miss anybody? Okay, thank you. Would it surprise you to know that I have to do absolutely nothing? I know some of you have heard my spiel before, but as the defendant, my client sits here absolutely 100% not guilty. He is not guilty the moment he walks in the door. He's not guilty as he sits in the chair. He's not guilty when the first witness takes a stand. He's not guilty when the last witness takes a stand. He's not guilty no matter what I do. The defense does not prove innocence. The state is required to prove the case beyond a reasonable doubt. The case must be proved by the state to a moral certainty that my client is guilty. So what that means is that my job is to do nothing. Now that's counterintuitive, right? To how we live our lives. Wouldn't you agree, sir? If you're looking at, don't you want to hear two sides to the story before you make a decision? Right? If you're on a jury, you want to hear both sides of the story before you make a decision. But in our system, that's not how it works. My client has the absolute right to remain silent. He has the absolute right not to present evidence. He has the absolute right to do nothing. And if the state does not prove their case beyond a reasonable doubt, the only verdict you can return is a verdict of not guilty. Do you know why that is, sir? Okay. It's because the state has all the power. They have the power to remove your liberty. They have the power of incarceration. They have the power to remove your property. They have the power to remove your children. The state has all the power. The defense does not. So with great power comes great responsibility. And with great power comes beyond a reasonable doubt. Okay? Do you agree with that, sir? I almost called you your name. I'm not going to do it. I hate using numbers.
Yes.
Okay. Does anybody disagree with that? Because there are other systems throughout the world where a person comes in and they have to prove their innocence. But that's not what we have here. Okay? Sir, Mr. 95. Do you have Any problem with that? The fact that my client has a right to remain silent? Okay, I thought so. You're right? Because do you look at that, if my client did not take the stand, that may be an indicator that he could be guilty? Okay? And because of that, do you think that you would be unable to be fair and impartial during this matter? No? Well, may I ask you to clarify? Because if you're saying, and I'm just trying to understand, because this is the only time I get to talk to you guys. You know, I can't run in during jury deliberations and go, hey, how's it going? You got any questions for me? So I want to make sure that when we're whittling this down, that I ask the questions that I need to ask. So if my client were to exercise his constitutional rights to remain silent, would you hold that against him? Okay. Why? You said before it would bother you.
I've been in a position where I didn't do no crime at all, but I was accused of doing a crime, but I didn't.
Mm-hmm.
I had to prove I didn't do the crime.
Okay. I understand that.
And the other person got off scot-free.
Okay. Okay.
But unless I proved that it wasn't me, it was credit fraud.
Oh, I understand that. So like identity theft kind of thing?
Yeah, 12 years worth.
Okay. So, okay, I understand what you're saying. And in here, this is a little different kind of forum here. But I do understand what you're talking. Because you had...
Being accused of a crime.
Right.
But I didn't.
Right. And you had to go through a ton of red tape and process and prove who you were and prove that you weren't, like, for me, I had to prove that I wasn't in Florida at this hotel during Christmas one year when my credit cards were used, when I was in Pacific City where I live. You know, I mean, so I get that. Does anybody else have, like, just this little buzz about, like, well, if you don't hear from him, that must mean that he's guilty? No? Okay. I mean, and that's, for a lot of people, that's just kind of what they think. And there's nothing wrong with that.
He had his hand up.
I'm sorry?
I agree that, I'm not trying to figure out how I'm supposed to say this, but I'm more prejudiced against the officers because I've had them lie on reports about myself. So I have a hard time taking what the officers have to say as true.
Okay. Do you think that because of this, and I don't mean when I start, I just want to say this, when I kind of interrupt somebody, it's just because you don't want to kind of poison the whole jury pool. So we kind of want to make our answers kind of short when it comes to like what your experiences. So do you think just because of your past experiences and your maybe feelings towards law enforcement that you would not be able to be fair and impartial to either party in this case?
I largely don't believe I could make a conscious decision either way because of my trust with law enforcement.
Okay, I'm just going to, the judge may have some questions for you.
So in order to, and there's no right or wrong answers, but you have to be in a jury, you have to take everyone who walks up the witness stand, whether they're an officer or not, and weigh them equally. Everyone's a person, whether you're an officer or not. So the question is, if an officer walked up to the stand, would they be at a disadvantage automatically as far as you're judging whether they're telling the truth because they're an officer?
Honestly, in my past, I don't think I could.
Okay. I'm going to let you go home, sir. Thank you for your honesty. You don't have to be sorry. Thank you for your honesty. Okay, so we're going to fill that seat. Next one on the list, I think, is 22, juror 22. Were you on a hardship hand up? Okay, come on up. And it's always tends to be the middle ones that. Okay. All righty. Good morning. What part of the county do you live in? And who lives in your home with you? What is your occupation?
I'm an office manager.
Have you ever been convicted of a crime?
No.
What are your hobbies and interests?
Reading art.
Do you have any close friends or relatives in law enforcement?
No.
How about prior jury service?
Yes.
This month?
No.
Okay.
I served 2 juries in LA.
Back when? In LA?
One is an alternate in a criminal case.
Uh-huh.
And one is a juror in a civil case.
Okay. Without telling me verdict's the one that you sat on that you weren't an alternate, did it reach a verdict? Okay. Thank you. Ms. Long.
Thank you. Juror 22, you know all the witnesses.
Yes. Except for one.
Okay. And how do you know them?
I was manager at Tillamook Canine Rescue for 4 years.
Okay. Okay. So that makes sense. So you dealt with them when they would have law enforcement, basically recovery of dogs that would come into the shelter.
Yes.
And did you deal with them in other matters?
Yes, I've dealt with them. I've gone to help take dogs from them on occasion. I've talked to them on the phone multiple times.
Okay. So would you have to go out on scene and take dogs when?
At one point, yes, I have.
Okay. Does that relationship with Sergeant Jackson and Trooper Hughesby and Deputy Patterson, do you think that could affect your ability to be fair and impartial in this case?
I think possibly yes. I have a long-standing relationship with them, so
yes.
Yeah, I think it would be difficult to. Trying to be impartial, but yeah, I think there's a
Okay. No, I understand.
Guess what? You get to go home. Thank
There's
you.
always a hot seat. Thank you.
So I'm up to 358. Who's 358? Did you have your hand up for hardship or not? Okay, come on up. Good morning. What part of the county do you live in? And who lives in your home with you? What is your occupation? Have you ever been convicted of a crime? What are your hobbies and interests? Do you have any close friends or relatives in law enforcement? How about prior juror service? Have you served before? Okay, thank you. Ms. Long, go ahead.
Thank you. Hey. Who here wants to be on a jury? There's hands. This is a surprise. Why?
It's interesting. It's a new experience.
Okay. Where do you sling beer?
Over at the Pelican Tavern here in town.
Okay. Okay. And you're friends with law enforcement?
My father.
Okay. Here in town?
Yes.
And for what division? What?
Sheriff.
Okay. For how long? Is he still there?
No, he retired.
When did he retire?
I was at least 20 years.
Okay. So it's not like do you keep up any of those relationships?
Most of them have moved on.
Okay. And I'm sorry, what was your father's name?
Slippery.
Okay. And anything about the fact that your father was in the sheriff's office?
Sometimes it was tumultuous. I was a little girl, so sometimes not knowing if that was something or not was difficult.
No, I understand. My husband's retired sheriff, so I get it. But anything about that growing up in that way would make you more unable to be fair and impartial? Okay. No. I'm not asking for elaboration. Okay? Okay. Sir, would you like to be on the jury?
I've never served on a jury. I was called once, but I was excused.
Okay.
Several years ago, before I moved back up here, I was a witness at the case. I had nothing to do with the case except that he was captured in my front yard and I found his weapon under my house. So
That sounds like you had a lot to do with the case.
I found it 2 weeks after the incident, and I didn't know it was a case.
Okay.
I just happened to look down and there was a case laying there.
Okay.
So I was there to testify why I didn't find it earlier. So I didn't know he would be involved or anything about the case.
Do you fly off the airstrip in PC?
Well, not currently. I fly at home sometimes.
You don't have the hangar that has the wrong size that they couldn't get the plane in, do you?
My dad helped build that airport.
Really?
Many years ago.
Okay.
When I was a child.
Okay. I love that place. Okay, who else wants to be on the jury? Yes, sir.
Just be interesting. I've never done it before, and it'd be nice to have a chance to have a civic duty.
Do you think you'd be a good juror?
I'd like to think so.
What do you think makes a good juror?
They're impartial, no preconceived notions on nuance that hasn't been presented.
Nuance. I really like that. I like that word. What about you, ma'am?
I think due process is really important.
Okay. Okay, can you expand on that?
I think it's really important that people get the opportunity that the state is required to take a moment before you take away someone's liberty to prove every component of the charge against them, and then have a chance to have your peers.
Okay. Would you agree with that?
I do.
Okay. Especially in this day and age? Okay. Who doesn't agree with that? You agree with that? Because when we walk in here, it's a blank slate. I mean, nothing has happened. May sound counterintuitive, but when we walk in here, there's a piece of paper that is a charging instrument. It says, my client is charged with this. But other than that, nothing has been proven. That means that Mr. Jeffrey Hall is absolutely 100% not guilty unless and until the state proves the case beyond a reasonable doubt, meaning every single element. Okay? You agree with that? Okay. And just because somebody is charged with the crime doesn't mean that the state or the government got it right. Okay? Everybody agree with that? Who watched football on Sunday? Hey? Hey, I'm going to do a sports analogy, and I do them horribly. But I watched football on Sunday. The only 2 games I watch all year, except for Super Bowl, and I watch them because I throw a Super Bowl party every year, and I have to know what teams are playing before my friends come over for my Super Bowl party. And there's always a call, a touchdown, that one of the coaches say, I don't agree with that. Let's take another look. And that's what a jury trial is. It's where the defense is saying, no, I'm not guilty. I didn't do that. Let's take another look. And the jury decides whether or not the state's got it right. Okay? If you're picked on this jury, can you all do that? I'm going to ask you one more time. First, I'm going to ask you all in the box. You all live in Tillamook County, right? Let's make sure we got that right. And can anybody here think of a reason that you should not be on this jury? Like, has something popped up where you're like, I was in Wells Fargo when it was being held up by a bank robber. Oh, I mean, think of any reason that you cannot be here tomorrow. This is so important. I've had cases before where jurors had just taken off, and then we have to do it all over again. Yes, ma'am. Okay, what's your number? I would ask that she be excused.
Okay, you're good to go. Thank you.
Have you seen social media clips about this incident? What's your
What was your number?
Who else
Okay.
have seen social media clips about this incident?
Oh, my goodness.
There we go. That's
Perfect example. So that's 93, you saw social media about, like, photos and stuff of what's happening?
and Your Honor, can we approach first?
Sure.
Oh, wait, I need to turn myself off.
Yes, otherwise we'll all hear you.
Don't hear me.
Okay, so juror 93, you saw video of the bank robbery stuff on social media. Don't tell me about it. Yes? Okay, you're good to go. Thank you. Juror 293, who's 293? Did you see social media of it?
No.
Come on up to, did you have your hand up for hardship?
No.
Perfect. You're a winner. Not that everyone else isn't, but come on up. What part of the county do you live in, sir?
Tillamook.
And who lives in your home with you?
My wife.
What is your occupation?
I'm retired.
What line of work?
Well, I did many things. I was a postman for 10 years. I was a general manager of public transportation, and I served in the Coast Guard for 18 years.
Have you ever been convicted of a crime?
No.
What are your hobbies and interests?
I like football.
Okay.
I like playing racquetball. I fish, hike.
Okay.
Lots of things.
Close friends, or do you have close friends or relatives in law enforcement?
Yes, I was in law enforcement.
Okay. In the Coast Guard or, okay. Were you a civilian law enforcement as well?
No.
Okay. Prior jury service, have you served before?
I think 2 years ago here.
Was it criminal or civil?
I believe it was civil.
And did it reach a verdict?
It did.
Perfect, thank you. Okay, other hands in the box who watched video of the bank robbery on social media? Yes, sir? Okay, you're good to go, thank you. I'm getting worried now. Okay, 298, who's 298? And you were the one that saw the social media as well? Okay, bye, have a good day. Okay. 375, who's 375? Did you see social media of that? Did you have your hand up for hardship? Perfect. Okay. What part of the county do you live in? And who lives in your home with you? What is your occupation? Have you worked outside of being a student? Okay. Have you ever been convicted of a crime? What are your hobbies and interests? Do you have any close friends or relatives in law enforcement? Okay. Prior jury service, have you served before? Okay, thank you. Anyone else in the box watch social media coverage of the bank robbery? Out in the audience. Okay, ma'am, your number? 158. Thank you. You're good to go. Your number? Okay, you're good to go. Anyone else watch social media coverage of the bank robbery? No? Okay. All right, Ms. Long, go ahead.
Yeah, turn back on. Okay. So I just want to make sure that we're clarified when we ask about social media about the bank robbery. Did anybody watch any YouTube, social media, or anything regarding my client and an interaction with Deputy Patterson? Or anything called, like, anything about interaction with my client? Okay. Okay. I'm going to ask again. Just want to make sure. Again, anybody think of any reason that they shouldn't be on the jury? Okay, well, I think I've talked at you for long enough, and I will pass this jury for cause. Thank you, Your Honor.
Thank you. Mr. Dietrich.
Counsel.
Wait, I'm going to turn off.
Hello? Good morning, ladies and gentlemen. My name is Jeremy Dietrich. It's good to be with you this morning. I know Ms. Long went through quite a bit, and I took my notes, so mine should be pretty shorter. That's one of the benefits of going second. You get to sit there and get to learn your jurors as opposing counsel will ask their questions. I get some feedback as well. Specifically, I was curious, these days we have a lot of social media. You got Facebook, X, you got YouTube. And we have a lot of local stuff, which was just being discussed. Has anyone followed a YouTuber or a Facebook account by the name of Hugh? I'm not. Does like a scanner channel? It goes follows law enforcement. Okay, so are you like subscribed to it?
I think I'm part of a group, but it was too many notifications, so I can go find it, but I don't think I can.
Mm-hmm. So have you seen? But whenever a video posts, it shows.
No, I have to go look for it.
Okay. The reason I'm asking is because in this case, you're going to hear evidence that's going to involve the defendant running that network. And I'm just trying to see who might be one of his subscribers or followers that might be. Yes. You unfollowed it? Is there anything you saw? I'm not sure if that's the same thing as this other scanner site. I don't follow much social media. But is that the...
Whatever scanner site, he was administrator.
Did you see anything from there related to anything about this incident or anything like that? Okay.
Your Honor, may we approach?
Yes.
Hold on. I have to do it with my left hand.
So who is the one that had unfollowed the channel? You're free to go. Thank you. Okay. So that brings up 375. Who's 375? Oh, you're already up there. Oops, never mind.
I have
12. Who's 12? Okay. Did you have your hand up for hardship, sir? Okay. Good morning. What part of the county do you live in? And who lives in your home with you?
My wife and my daughter.
What is your occupation?
I'm retired. I was in computer management.
Do you have you ever been convicted of a crime?
No.
What are your hobbies and interests? Do you have any close friends or relatives in law enforcement? How about prior jury service?
Just this month.
Okay. Were you on one of the ones that hung? Were you, did it stop in the middle or the other one?
The one I was on, the trial did not completely never deliberated.
Okay. Thank you. Mr. Dietrich, go ahead.
Thank you, Your Honor. I just want to be clear. I'm not sure how many channels or whatever there is, but my understanding is Hugh Janis has some networks on social media. Now, could I get a raise of hand of anyone who follows those? You follow it? What's your number? And we have juror 359. Is there anyone else? Okay, and you continue to follow it?
No, now that I know that that's the name associated with it, but I did not have a good.
So you unfollowed it?
Okay. Thank you. You're good to go. Juror 131. Anyone? Are you 131? Were you going to want a hardship to sit? No. Okay. Thank you. Go ahead and have a seat. What part of the county do you live in? And who lives in your home with you? What is your occupation?
I'm cashier.
Have you ever been convicted of a crime?
No.
What are your hobbies and interests?
Watching my grandkids do work.
Close friends or relatives in law enforcement?
Like that.
And have you served as a juror before?
Yes.
Was it this month or before?
Before.
Okay, was it criminal or civil? Did it reach a verdict, but don't tell me what it was? Okay, thank you. Mr. Dietrich.
Okay, I believe there were a few more hands. It was juror 62. That was you. So you said you follow it as well? And are you still following it? Is there anything from following that channel associated with the defense that might have any influence as far as how you evaluate if you're chosen?
Your Honor, I'm going to just ask that 62 be
How many other people besides 62 follow whatever channel this is, or unfollowed whatever channel this is? Nobody else? Ma'am, I'm just going to... Say it again, Mr.
It's like a Hugh Janis.
It's spelled H-U-G-H space J-A-N-I-S.
Hugh Janis, which sort of sounds like a weird other word. I was just thinking, but...
Is that what the channel's called?
Apparently. Is that what the channel's called? So, no, you don't follow that?
And there's also Tillamook Uncensored. Sorry to interrupt, I just want to
Oh,
make
you're
sure.
fine.
Tillamook Uncensored. Does anyone else follow that channel?
Okay.
I mean, I'm on it. I don't follow it literally or get, the amount off my feed, but occasionally when you hear something through the speaker or something, people will post on there. So I'm unfamiliar with that name, but that is the case.
Okay, so juror, was it 61 in the black? 62, you're good to go. And Somebody asking me to excuse 97?
97.
Up here. She says there's something she occasionally goes on to, the uncensored one. Is she being challenged by the state or defense?
Your Honor, could I ask some follow-up questions? I was just looking for 62 on here. I wasn't able to find
Last page.
Oh, gotcha. Oh, I see what you're saying. Understood. I guess this was juror 97?
Correct.
Is there anything from, I guess, following that you picked up any information about this incident or opinions or comments as people scream back and forth and irrational rants, like on the comment sections?
I'm going to object with regards to his characterization.
Just a sec, overruled. I mean, comments are just crazy no matter what you watch.
You
People
know
trolls.
how people post something and then everyone just starts commenting their thoughts and
And there's no recollection of certain topics that I've seen on that meeting.
Okay. Is there anything that you believe would bias your ability to be fair and impartial in regards to this trial?
No, like I said, that name doesn't, there's nothing attached to that name for me.
Okay. Generally, we've kind of had a conversation earlier, not with me, but as far as law enforcement, because they're sworn officers, they have training, and then we had one juror just acknowledge he would have a problem. Before we go forward, I just wanted to see, does anyone else just kind of had an experience or just kind of have a personal view? I'm not saying right or wrong. Everyone's free to have a view, but that they just don't like police officers or trust them, that could be an issue just in its own nature. Yeah. Huh? What do you mean by that? Currently you don't, but in the past you have?
It is something that has influenced my thoughts growing up.
Yeah, I'm sorry?
It's something that negatively influenced my thoughts growing up.
Okay.
But that was a different time. Things have changed.
Whether it was just a general kind of opinion or something personal that was traumatic to you or whatnot, because we know we all have biases, and you're going to hear the jury instruction stuff about unconscious bias. Is there any concern that you would have that if you heard an officer testify, you would just kind of default not trusted? Okay, so this was a pretty long time ago? Okay, so you can be fair and impartial? No, you can't. Anyone else? What's the other thing? I want to ask just one question, just to see if anyone's ever experienced something like this. When an officer has given you an order that you've disagreed with, whether you're being pulled over, put your hands on the steering wheel, or get out of the car, has anyone had that personal situation where they're being directed to do something by a cop themselves? We got 1, 2, 3, 4. From any of those incidents, was there anything that occurred as far as you were in disagreement or you refused, or that might impact how you evaluate a case like this? No? No? Okay. So there wasn't anything significant about it? Okay. No hard feelings that were left that kind of just you kind of carry with you, you're still upset about whatever that was? Okay. And briefly, I wanted to come over to the few remainders who apparently aren't as active on social media. Excuse me. Looks like, is there a juror 71? It'd be you, sir. We spend a lot of time up here, so I just kind of want to generally just kind of go through a number of your last ones here. And I think we went and asked everyone where they're from and all those questions. And I don't really pay much attention a lot to the back row. But as we decide jurors and they go away, you guys come up. So it's kind of important for me to get to know your guys' kind of thoughts as well. Out of everything you've heard today, for myself or, yeah, I get close to that other mic. I'm just going to stand up front. I won't get too close. Keep that mic from going. For instance, juror, let's see here, what was I?
71.
Let me do an arrow. What do you do? Business owner? In Neathart? Okay. How long you been in Tillamook County? 25 years?
You're next up, sir, if we lose somebody.
You think you can be fair and objective to both sides?
Yes.
Okay. And how about 143? Yes, sir. What do you do?
I'm retired.
Retired? How long have you lived in Tillamook?
Jeremy, can you back up a little bit? You're still.
I'm still doing it.
Yeah, still doing it.
Actually living in Tillamook about
7 years? Where'd you come from before? Portland? So this is kind of a good area, get near the beach close to? So you came here kind of like retire or?
Yeah, we had a small place in the Narrows community for a number of years. And when I retired, I decided to
Down here. Any issues with you as far as what you've heard today where you think you might have a bias or concern or issue? Okay.
Mr. Dietrich and Ms. Long, can you approach?
I'm sorry.
Nothing further on.
Ms. Long, there's some new people in the box. Do you want to do any additional questioning or pass?
I will pass this jury for
Each side is allowed to excuse a certain number of jurors. If you are excused, you should not feel that your attendance has been without value. The court needs a substantial group of available trial jurors so an impartial jury can be selected. All of you here today provide an important contribution to the process, and your presence assures fairness. With that in mind, the remnants of you are free to go. Have a good day. And I think we're almost done with the month. Let's see. I don't think.
Yeah, we're done.
I think we're done. Aren't we done with the month? Yes. You don't have to call in anymore. Thank you. Busy month. Okay, you 12 are going to be winnowed to 6 lucky and unlucky people based on, I guess, your goals for the day or tomorrow. So we're going to do that in a few minutes. I'm actually going to have everybody step out and look at the mural or wander around in the hallway. It will be a few minutes, and I'll have you back into your seats, and I'll tell you who's staying and who's going. Thank you. Yes, you'll be down to 6. When you come back, I'll tell you. No, can't. You're banned from leaving. And we can go off the record. Challenges, obviously 95 to 131 are the presumptive 6. Mr. Dietrich.
State would like to remove juror 298 and seat 8.
Okay, they're not,
That's not up.
there's no 298. So we have,
293.
that's not of the first 6. The first 6 are 95, 97, 87, 12, 375, 131.
Oh, duh. I'm thinking it's a felony.
No,
Sorry.
it's okay.
I've had too many felonies. I got to get back to a misdemeanor. I'm good with the top 6.
Ms. Long.
95.
That puts up juror 106. How do you feel about 106, Mr. Dietrich?
I'm good.
Ms. Long?
106.
That puts up 293. How do you feel about 293, Mr. Dietrich?
Yes. Okay.
Okay or challenge?
Challenge.
Challenge. That is the seat. Okay, that puts up 329. Ms. Long, final challenge.
$131, seat 6.
That puts up juror 358. So, Mr. Dietrich, how do you feel about 329 and 358?
Challenge 329.
That puts up 306. So how do you feel about 306 and 358?
Pass.
Pass? Okay. So we have 306, 97, 87, 12, 375, 358. Everyone on the same page?
Yes.
Okay. So what we will, did anyone need, what I was planning on doing, do the seating changes, swear them, read precautionary, give them a little break. I think we can do opening.
Can I ask that we do opening after lunch, just because
Yes.
I have to talk to Salvo and Bruner.
Okay, that's fine.
I'm going to, since the direction, if I may step out once the jurors back in, they're surrounded. I have 2 officers, I believe, that are out there. And if we're going to kick it off at 1:30, I was going to have them come back.
Okay, so yes. So let's have you do that. We'll bring the jurors in. I'll do precautionary and we'll excuse them for lunch and we'll come back at 1:30.
Thank you.
Okay.
Judge, before they go out, did you say number seat 5 is 375?
That's what I have. That's it.
375.
306, 97, 87, 12, 375, 358.
That's what I have too. Okay.
And then 358 was the last one?
Yes. Okay, go ahead, Mr. Dietrich. We'll go off the record briefly. Then we'll bring in jurors. Changes, don't take it personally. The good news is no more trials this month, so you're off the hook until the computer in Salem picks you again. So with that in mind, juror 95, you're good to go, and juror 131, you're good to go. So, juror 306, you're going back up here. And juror 358, you're at the other end. Okay, so let me verify, because the other day I released people too early. 306, right? Make sure I'm getting your numbers right. 97, 87, 12, 375, 358. All right, you 4 in the front are good. Have a great day. You get to go. Yep, dismissed. Thank you. All righty. Go ahead and stand up, raise your right hands, and be sworn in as our jurors.
Do you, and each of you, solemnly swear that you will, well, and truly try the matter at issue between the plaintiff and defendant and a true verdict render according to the law and the evidence as given you on the trial? So help you God.
Perfect, everyone. Go ahead and have a seat. So I want to go through the procedure. I'm going to go through some housekeeping kind of stuff. I'm then going to read you what are called precautionary jury instructions, then we're going to break for lunch. During lunch, you'll be free to run home, run errands, go out to eat, whatever you'd like. I'll have you back at 1:30. I have unrelated cases at 1 o'clock I need to deal with, so 1:30 will come back. I do not know if we are going to be able to get done today. Possibly, in which case my guess is jurors would usually rather push into the evening a little bit with some pizza rather than come back the next day, but we'll see where we are with that. Or you may need to come back tomorrow. So we'll just see how things go this afternoon. When you come back out this afternoon, please sit in the same seat but forward a row. It just gets you guys a little bit closer so you can see and hear a little bit better. Hot and cold, this courthouse, there's nothing really I can do, so put on your jacket, take off your jacket, whatever. There are waters back there. There's a Keurig that you're welcome to use. There's some magazines. If our magazines look boring, you can bring a book or do something like that. Usually trials have natural breaking points, but if you need a restroom break or some kind of personal break and I am just going for it, let me know. Of course, I'm going to give you a personal break, but usually that doesn't tend to be an issue. I know the chairs are kind of historical and uncomfortable. At least they have cushions. So that's kind of our game plan. Really important, if you can't hear anybody, the microphones are super directional, so if you can't hear anything, question, answer, anything, let me know immediately so I can have it restated for you. So that's kind of our game plan for the next day and possibly into tomorrow. Members of the jury, I will now explain some of the rules that apply during a trial. There are 8 stages to most trials, and I will briefly explain each stage. First is jury selection. Obviously, we just completed that. Next is explanation of the general rules, and that's what I'm doing now. That's followed by opening statements. This is when the attorneys summarize what they expect the evidence to be, and when you come back, that's the first thing you'll be hearing after lunch. That's followed by presentation of the evidence. This is when witnesses and exhibits are presented. Next is jury instructions. This is when the judge explains the law that applies to the particular charges in the case. This includes explaining what the state must prove beyond a reasonable doubt for a guilty verdict. You will receive a printed copy of these instructions. That's followed by closing arguments. This is when the attorneys have the opportunity to persuade you how to decide the case. Next is deliberations. This is when you go back to the jury room and decide whether the defendant is guilty or not guilty of any particular charge. Finally, return a verdict. This is when you come back into the courtroom to tell us your verdict. I will explain in a moment what is and what is not evidence. It is extremely important that you consider only the evidence in deciding the facts. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision-making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Unconscious bias is a term used by social scientists to describe the reality that everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes called unconscious biases that we may not be aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Our biases can affect how we act favorably or unfavorably towards somebody. You should make every effort to be aware of your unconscious biases and what effect those may have on your decision making. As a judge, I am a gatekeeper regarding evidence. I determine what the law allows to be evidence. In effect, the law considers anything that is not evidence to be unreliable, and that is why you may not consider non-evidence in deciding the facts. However, the law does not conclude that anything that is evidence is necessarily reliable. Determining the reliability or believability of evidence is ultimately your responsibility. You must decide what evidence is believable and how believable or persuasive any particular piece of evidence is. So while you are not allowed to consider anything that is not evidence in deciding the facts, you are free to decide how believable or unbelievable, important or unimportant any particular piece of evidence is in deciding the facts. Evidence consists of testimony of witnesses and exhibits that are admitted into evidence. Testimony is what a witness who is sworn or affirmed to answer questions truthfully says while being examined as a witness. Exhibits are physical objects, such as photographs, charts, or letters. You will be able to examine admitted exhibits during your deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it is helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defendant is innocent of any crime unless and until the state proves the defendant's guilt beyond a reasonable doubt. Questions from lawyers are not evidence. So whenever I sustain an objection to a question, do not speculate about why the questioner was asked or what the answer would have been. This is a subtle but important point. In our everyday lives, if a friend asks us, "Hey, have you seen our neighbor's new car?" we would infer from that question that our neighbor does in fact have a new car. However, it is not the same in a trial. The person asking the question is not a witness and is not subject to the safeguards that the law requires before you may consider the person's words as evidence. So in court, you are not allowed to consider questions asked by attorneys in determining what the facts are, because those questions themselves are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. So if, for example, a lawyer asks, "Was the traffic light red or green?" and the witness responds green, you may take the answer stating that the traffic light was green. However, if the witness responds to that question by saying, "There was no traffic light," you may not take the question about the traffic light as evidence that there was in fact a traffic light. From time to time, a lawyer may object to something that is admitted into evidence. I will decide whether the objected to material will be admitted into evidence. If I overrule the objection, material, for example, an exhibit or a witness's answer to a question, becomes evidence. If I sustain the objection, the exhibit is not admitted and is not evidence, or the witness is not allowed to answer the question. If the witness starts to answer a question before I sustain an objection to the question, you must disregard the witness's response because the response was not evidence. Occasionally, I may decide that something that has been admitted in evidence should not have been. If that happens, I will instruct you to disregard the exhibit or testimony that should not have been admitted. This means that the material is no longer evidence, and you must not consider it in any way. You must treat it as if the question had not been answered or the exhibit had not been received in the first place. You must not interpret any statement, ruling, or remark I make during this trial as any indication that I have formed any opinion about the facts or the outcome of this case. You and you alone are to decide the facts. You must decide how believable the evidence is and what weight or value you will give that evidence. You may take notes if you wish during the trial. However, please keep in mind that each party is entitled to the considered decision of each juror. Therefore, during deliberations, you should not give undue weight to another juror's notes if those notes conflict with your notes or your recollection of the evidence. Do not allow your note-taking to interfere with your ability to observe and evaluate testimony. Your notes may be in only two places, the courtroom and the jury room. You may not take your notes with you on lunch or overnight breaks, for example. My staff will make sure your notes are safe and that no one has access to them in your absence. And for those of you who wish to take notes, there will be notepads and pens for you to bring out this afternoon. Do not discuss this case during the trial with anyone, including any of the lawyers, parties, witnesses, your friends, or members of your family. This includes not communicating with anyone by any other means, such as telephone, text messages, email, internet chat, blogs, or social networking websites. Do not discuss this case with other jurors or look at other jurors' notes until you begin your deliberations at the end of the case, after you've heard all of the evidence and the arguments of the lawyers and have been instructed of the law that applies to this case. Each of you must keep an open mind throughout the trial and must not attempt to decide the case until you begin your deliberations. Do not make any independent personal investigations into any facts or locations connected with this case. Do not look up any information from any source. Do not communicate any private or special knowledge about any of the facts of this particular case to your fellow jurors. Decide the case only on the evidence received here in court. Do not read any news stories, listen to radio or television reports, or read or listen to anything on the internet about this case or anyone involved in this case. In addition to conventional research, you also must not use any internet search engines such as Google to look for any information about the case, the law that applies to the case, or the people involved in the case, including the defendant, the witnesses, the lawyers, or the judge. Do not use any map program or mapping system to attempt to view or locate any of the locations that may be discussed in this case. In short, do not communicate with anyone by any means concerning what you see or hear in the courtroom, and do not try to find out more about this case by any means, other than what you learn here in the courtroom. Decide the case only on what happens in open court, where both the state and the defense are both aware of and have the opportunity to question the sources of the evidence and to address any legal issues that may arise. That is the only fair way to decide a case. If you base your verdict on anything other than what you learn in the courtroom, this could be grounds for mistrial, which means that all the work that you have done, your fellow jurors, the parties, the lawyers, and the judge have done will have to be done all over again. That is why this is so important. If you were to willfully disobey any of the court's orders in this respect, you could be held in contempt of court. Ignore any attempted improper communication. If any person tries to communicate with you about this case, tell that person that you cannot discuss the case because you're a juror. If that person persists, simply walk away and report the incident to the court. Please be careful in the courthouse. It's small. It's easy to overhear, and we've had trials get messed up because somebody overheard somebody talking in the hallway or whatever, so just be very careful about not talking to people in the courthouse or, hopefully not overhear anything that's going on in the courthouse. You may not talk to anyone about this case, even the people closest to you, except to say that you're a juror on a criminal case and the judge says you can't talk about it. After you have rendered your verdict or been otherwise discharged by me, you will then be free to do any research you choose and to share your experiences with anyone you choose, either directly or through your favorite electronic means. Remember that all phones, laptops, and other electronic devices must be turned off while you're in court and while you're in deliberations. You're welcome to use them in the jury room during breaks. There's Wi-Fi in the courthouse. Obviously, there's restrictions on what you look up, but I went through with you a few minutes ago. But other than that, you're welcome to use Wi-Fi during breaks. However, the bailiff is going to take all your electronic devices away from you while you're in deliberations. We do this in part to prevent anyone from even questioning whether jurors are engaging in improper communications while they're deliberating. After lunch, you're going to hear the opening statements in which the lawyers will outline the evidence as they expect it to be. After the opening statements, the evidence will be presented. At the conclusion of the evidence, I will instruct you about the law that applies to this case. The lawyers will then make their closing arguments to you, and you'll begin your deliberations. At the end of the trial, you'll have to make your decision based on what you recall of the evidence. You will not have a written transcript to consult, and it is so I urge you to pay close attention to the testimony as it is given. As I said at the beginning, if at any time you cannot hear a question or an answer, let me know immediately by raising your hand. In performing your role as a juror, you must, of course, be fair and impartial. You must follow the law, whether you agree with it completely or not, and you must not allow yourself to be influenced at all by personal feelings, sympathy for, or prejudice against anyone involved in this case. So with that in mind, I'm going to have you go back to the jury room to talk to the clerk for a few minutes. She's going to release you the lunch, From there, I have everyone back at 1:30. She'll tell you how to let yourselves back in the room or whatever. Thank you for paying attention to a long morning, and I'll have you go with Sandra back to your room. So thank you.
You need to stand up when the jury walks in.
Okay, welcome back. I hope you had a good lunch. Opening statement.
Thank you, Your Honor.
Yes.
I forgot my notepad.
Yes.
Would like it.
Yeah,
Okay, sorry.
it's okay. She's gonna get it.
I'll grab it for you. Yeah, thank you. Thank you.
And good afternoon now. Again, this is an opening statement. It's kind of a chance for me not to argue the case, but just to give me an opportunity to tell you what the state anticipates the charges will be. I'm gonna have to put it down on like my buckle. This is still way too loud.
Really annoying.
Hello? Still too loud? I don't know how much lower I can get it. Speaking from down here, from the gut. This is now it's hitting the paper. This is an incident from September 13th of 2024. You're going to hear how there was, it was unknown at the time exactly what was going on in the Wells Fargo Bank, just here on 3rd Street, I believe, a few blocks away. And a lot of people were going for an armed robbery. Law enforcement were setting up vehicles between the road, trying to clear it. You're going to hear how they were stacking, getting ready to basically breach into the building. It was still unclear really how many people were in the bank, the types of weapons. And so as this is going, Deputy Patterson is put to post on the street that kind of goes across. So the bank would be here, and then the Safeway's over here. So he goes up a little bit more to that intersection that goes this way, and then the bank's there. And he sets back a little bit, and you have 2 patrol vehicles you'll see on the videos that we see. And so he has a long rifle, and he's basically cover fire. So if anything happens, he has a view of the bank, so if anyone's coming out, or if fires are being shot in any way. So he's in a cover position. And as this is happening, a number of people, naturally, they want to see what's going on. So Deputy Patterson, he asked a bunch of individuals if they could back up further behind the vehicle, and everyone backed up. At that time, the defendant came up and would not back where the rest had gone. So Deputy Patterson asked him as well. And Deputy Patterson, you're going to hear from him, his main concerns, it's not just that, as he'll describe it, the public safety of if firing starts happening. He's going to testify of the concern that when you have people recording law enforcement in positions, as a deputy and the officers, there's concerns that they might be feeding information into whoever's involved in the bank. And so he's like, I really want you out of your position. Can you go back over there? The defendant acknowledges what he's requesting and simply says no. And you're going to hear some body cam exchanges, and Deputy Patterson testify about that. Deputy Patterson finally decided, well, I'm going to make him go back and walk him back. As he's approaching him, the defendant and Deputy Patterson, you're going to see one of those moments in life where people are screaming and no one's really listening. And so he's screaming, you need to go back. The defendant's screaming, no. And he kind of takes him backwards, and the defendant starts to resist, pushing back. I'm not going. And so that pushing gets escalated, and it keeps getting escalated to the point where Deputy Patterson, you're here, and you'll see in the body cam, is trying to actually put him in handcuffs and the defendant is just actively not letting him. He's just no. Eventually, you're going to see and hear from Trooper Hughesby, because it's at this time that Deputy Patterson, he calls for help. He needs someone else because he can't get the defendant into handcuffs because he's actively pulling out. And so Trooper Hughesby was at the front of the bank where the ATM's located. And suddenly, as they were about to breach, they realized one of their cover fire officers is no longer in his position. He's back dealing with the defendant. So they have to stop the breach. Trooper Hughesby has to run across the intersection to where they're gone. And he has to break it up and go like, hey, this isn't the moment. Let's stop it. We're breaching right now. We need you at the truck. So Deputy Patterson goes back to his position with his long rifle. And then they breach the bank. So it's a pretty short fact pattern. Overall, the incident only occurs about 5 to 10 minutes before they're inside the bank and resolving the individuals or whatever that were in there, which aren't necessarily relevant to this aspect. As far as who or how many were in the bank, that's not really what this trial is about. However, later, Sergeant Jackson went and spoke with the defendant, and Sergeant Jackson had a conversation from his perspective that he provided to Jackson about what occurred. And you're going to hear basically Sergeant Jackson state that as the defendant's talking to him, that the defendant believed he was in a better deciding position to decide where he'd be recording than Deputy Patterson. So during his conversation with Sergeant Jackson, he acknowledges the order, he understood the order, and he simply felt he didn't have to follow it because he had a better judgment too. And you're going to hear the disconnect between understanding the ultimate concerns the deputy had as he's testifying. It's not just the public safety, it's that I don't know if you're feeding intel inside the bank because you're recording all the officers, everything's live streaming these days, and you'll hear those concerns. And he simply disagreed. So Sergeant Jackson's also talking to him, and basically that was consistently what you're going to hear from him, that, yeah, he knew and he didn't. And then I think when it's all over, you're going to show that he was there. Deputy Patterson tried to get him back. He actively resisted. It got out of hand. And ultimately, someone who was about to breach had to put a mission on pause, run back to deal with the shenanigans, and then run back to take care of a more serious matter. Because at that time, you're going to hear they weren't aware of whether they got assault rifles in there, what to expect as they're entering. And so subsequently, when it's all over, the state's going to be asking you to deliberate and come back with a verdict of guilty. Excuse me, for this thing's hitting me. And this is, I need to find a better way. I appreciate your time.
Thank you, Ms. Long.
May it please the court,
This thing just doesn't
counsel, ladies and gentlemen of the jury. Let's see if I can do this a little.
Here, try this one.
No. Not falling for it. Got me? Got me? Got me? I'm never quiet. Got me? Got me? Okay. 3 minutes and 38 seconds. That's how long the interaction was between Deputy Patterson and my client. During that time, Deputy Patterson had an assault rifle, his sidearm, and a taser. He attempted to tase my client. He grabbed him, he pushed him, and he raised his fist to him. Why? Because on this day, the evidence will show that Deputy Patterson took things too far. On September 13th, 2024, Philip Reese attempted to rob the Wells Fargo Bank. Every officer from every department was called out. Now, Deputy Patterson had a lesser role. He wasn't one of the ones that went into the bank. He was out by U.S. Bank on 4th Street, where there's a brick building. Now, he was posted up there in an area where there were other civilians back behind him. Civilians, including my client, who had a phone and he was videotaping, which, as civilians, were allowed to do. Now, evidence will show that Deputy Patterson allowed other civilians to walk through this area. Like, walk right through. For whatever reason, he didn't like what my client was doing. And he told him to stop and get back, although he was in the same area localized as other people. The only difference is that Deputy Patterson just didn't like what he was doing. Now, Trooper Hughesby didn't come over because there was a call for help. What Trooper Hughesby is going to testify to, I hope so, because this is what he wrote in his report, is that he looked over and he noticed that Deputy Patterson was getting into a verbal conversation with my client and that it was getting a bit heated. That he saw Deputy Patterson giving commands to get back, something about those lines, and saw Deputy Patterson advance on the male citizen. Then he asked for another unit, and he ran over to assist. And what Trooper Hughesby's opinion was that my client wanted to film the incident and was probably standing closer to the incident than Deputy Patterson wanted, and that he ultimately, Trooper Hughesby, got in between Deputy Patterson and my client to stop Deputy Patterson for continuing his assault against my client because, as he stated in his report, I didn't think Hall was committing a crime and was only being an annoyance. In our country, you have a right to be annoying. That's not against the law. And I'm going to ask that at the end of this case, you return the only just verdict, and that's a verdict of not guilty.
Thank you, Ms. Long. First witness?
Yes, Your Honor. State will call Deputy Travis Patterson.
Good morning. Come on up. Come on around this side of the table. And then stop and raise your right hand and look at the clerks.
Under penalty of perjury, you solemnly swear or affirm that the evidence you give in this matter be the truth, the whole truth, and nothing but the truth? Right.
And then come on up here to the witness stand. Morning. So it's hard to sit with all the gear in that chair, but do your best. Can you tell us your name, please, and then spell your last name only?
Deputy Travis Patterson, Patterson.
Mr. Dietrich.
Hi, Deputy Patterson. I wish you a good afternoon. A few questions about the Wells Fargo bank robbery. Do you remember that day?
Yes, sir.
I believe that was on September 13th of 2024.
Yes, sir.
Do you know around what time of day it was?
I believe around noon, 1 o'clock, but I'm not sure.
Okay, and how was the weather?
Sunny.
Okay. And when you got there, were you given instructions about where to post or where to set up?
Yes, sir.
And where did you post up at?
I believe it was on 3rd Street near Safeway and U.S. Bank.
Would you enjoy a board where you can write it out?
Sure.
Okay. May I, Your Honor?
Yes. One of you gals give Mr. Dietrich the board, please. We don't ever have non-functioning pens.
Thank you. Should I give him the mic?
Do you want to give him that one?
And Deputy Patterson, you're going to want to block me, so if you want to go parallel with this, so the jurors can see what you're doing.
It's mic'd up. This is the way the record will catch you.
Okay.
So why don't you tell us where is Wells Fargo in this scenario?
I'm going to try to draw as less crudely as I can. That's Safeway, 3rd Street, and Pacific, and that's Wells Fargo, Safeway, and I think U.S. Bank.
What bank?
U.S. Bank.
Okay. And where was your vehicle? Maybe use a different color for vehicles.
Believe somewhere around here, and then there was another vehicle here. So I would have probably been here.
Okay. And so that's your zone?
Yes, sir.
Do you want him to have a seat or stay there?
Okay. Do you want this back? Sure.
So, Deputy Patterson, why don't you tell us how long you've been on law enforcement, or in, I want to say, is this your first employment as an officer? Or?
Yes. I was hired June of 23.
And that's with the Tillamook County Sheriff's Office?
Yes, sir.
What kind of, I guess, law enforcement, if any, did you have prior to that?
I worked security for the courthouse prior.
Okay. How long did you do that?
I believe 2 or 3 years.
Okay. And when you were assigned to Tillamook County Sheriff's Office, what was your function and role, like a job?
I was a patrol deputy.
And what do patrol deputies do?
Respond to calls or patrol specific areas that we're assigned to.
Unlike maybe a jail deputy?
Correct.
So on this day, you were posted up, is that correct?
Yes, sir.
What was your function that day?
So I was maintaining long cover of the entrance of the bank with a rifle.
And what's the purpose in long cover?
So I was to maintain security and make sure that whoever was inside the bank wasn't exiting the bank or creating a public danger.
Okay. Do you know a Jeffrey Hall?
I do now, sir.
Did you not know him prior to this?
Correct.
Correct?
I did not know him prior.
Is he in the courtroom today, do you know?
Yes, sir.
Could you point him out and describe what he's wearing?
He's wearing a gray shirt and dark pants.
Is that enough for the record to reflect?
Yes.
So the defendant was the individual you had some issue with, I guess, of some sort on September 13th?
Yes, sir.
And that's here at the bank in Tillamook. Is that in Tillamook County?
Yes, sir.
So what exactly occurred that made you concerned about this particular individual?
So on the diagram, I was stationed behind my vehicle facing the entrance of the bank. I had a group of people who were standing behind me, and I'd asked them to move. Where we were, if someone were to exit the bank and start firing, I would have been most likely in the line of fire. My main concern was the safety of people behind me, and also scene security. Anyone who's outside the bank could possibly be involved with anything happening inside the bank.
And the other people, what did you tell them?
I asked them to move further away and behind a set of vehicles that were behind me.
Okay, and did they move so, or?
Yes, sir.
Did you ask the defendant, Mr. Hall, to move?
I did.
Okay, and did he move?
No, sir.
Okay. I have what's been marked as State's Exhibit 1. It's Deputy Patterson's body cam. I believe this is the one.
Any objection to States 1?
No.
States 1 is admitted.
Move to publish?
Yes, you can publish. And Deputy Patterson, you can move toward me and block me. Don't worry about it, because it's going to be right up above your head, so you can scoot back.
Okay, I think I'm going to need you guys to turn on the telly. I am. Should I unplug and put it in again? Okay. Okay. And Deputy, as we're watching this, I noticed there's no sound. How come there's no sound?
It takes about 30 seconds after activation of the body camera for sound to come on.
Who's gonna go arrested? What's your name? Travis Patterson, Deputy 211. Not anymore. Get behind the vehicle. Not anymore, Travis. Stop. You lady. Stop. 211, is she covered? Stop. Don't stop. Stop. Dean, stop it. Give me your other hand. You are under arrest. Give me your other hand. I'm not under arrest warrant. Interfering. I'm interfering what? Turn around. Do it now. I have our turn around. Turn around. Turn around.
Is that from your body cam?
Yes, sir.
I heard you say something about 211 over your comm?
Yes, sir.
And what is 211?
That is my radio number.
Right. What were you yelling 211 on?
I'm sorry?
Why were you yelling 211 on the comm?
I was trying to get assistance from other officers.
Okay.
And I believe Mr. Hall asked to identify myself, in which I did.
Okay. Did you ever radio for help?
I did.
And what codes used on that?
I just asked for a cover unit and used my radio number and do it, so.
That's what that means. Okay. When you came up to Mr. Hall, I was curious, could you answer, was there any physical contact between the two of you?
Only after I had attempted to move him.
And what did he do when you attempted to move him?
He pulled away from me.
Okay. What else did you do?
I tried to move him behind another vehicle.
Okay. And then how did he respond to that?
By pulling away from me and pushing against me.
And then from there, what happened?
I believe I got him closer to the vehicle, away from an area in which I wanted to remove him from, and he pulled out of my grasp and spun to face me.
Okay. And then after he spun to face you, what actions did you take?
I drew my taser and took it off safe and placed it against his chest, but I did not activate the taser.
And then after that, what occurred?
OSP Trooper Jace Hughesby arrived on scene to help.
To help?
Mm-hmm.
And after he arrived, what occurred?
We were informed, or he informed me that a team was being ready to enter the bank, and he separated Mr. Hall from myself. I went back to my cover position, and Mr. Hall left the scene.
Okay. Is that just what you're assuming, or do you recall what he specifically told you, though?
Either let it go.
Objection. Who are we talking about?
Trooper Hughesby, you mentioned he said something.
Objection, Your Honor, hearsay.
He already answered it.
That doesn't make it not hearsay. I didn't hear the whole thing. So the question is, say it again.
Well, he said Trooper Hughesby said something, and there wasn't an objection, so I was clarification of, are you sure that's what you heard from Hughesby?
I'm going to object hearsay.
And the purpose of the statement?
I guess clarification of exactly what he heard.
Sustained.
So at that point, I guess after Hughesby runs off, what do you do next?
I take position behind my vehicle again and maintain cover of the bank.
Okay. And how long after you get back to your vehicle did they breach into the bank?
It was immediate.
Okay. And were you in full uniform that day?
Yes, sir.
With your badge?
Yes, sir.
And your vehicle, did it display law enforcement insignia?
Yes, sir.
At any time did Mr. Hall, the defendant, did he notify you or apprise you that he was press?
I believe he made a statement saying that he was a member of the press.
Okay. Did you personally see any press badge or anything like that?
No, sir.
Would that have changed your assessment of what you did?
Maybe slightly, but I still don't know who he is in that time.
At this time, Your Honor, I'd like to move State's, I guess, agreed upon, State's Exhibit 2, which was the defendant's camera, which he had on his person at the time.
Stage 2 is a physical camera?
It's like a body cam. It's like body cam.
So video, so stage 2 is video, and do you object?
Oh, no.
Okay, stage 2 is admitted. You want to publish, you can?
Yes, Your Honor, move to publish. Oh, I'm sorry. I shouldn't have my thing sitting out there.
Your name? Move! Don't touch me! Don't touch me! Get behind the fucking vehicle! Don't put your punches! What's your name?
It's on me. It's froze up, Your Honor.
Go arrested. What's your name? Travis Patterson, Deputy 211. Not anymore. Get behind the vehicle. Not anymore, Travis. Stop. Hey, you lay your hands off me, Travis. Stop. Lay your hands off me. 211, I need cover. You stop. Don't touch. Stop. Stop. Hey, stop it. Give me your eye behind your police line. Give me your other hand. What am I under arrest for? Interfering. Turn around. Interfering what? Turn around. Do it now. I have our condition. Turn around. Turn around. Turn around. Travis, let it go. Let it go. I'm behind the police line. Travis, by the way. Keep behind the truck. Yeah. By the way, Travis, you're losing your job over this.
Did you personally see other people in areas of concern?
No, sir.
Were there other people like on bikes or walking around closer to the bank?
Not within where I could see, and not directly behind me.
So from your perspective, the only person you had concerns with then, you're saying there was no other concerns, is that what you're saying?
Correct, sir.
Except for Mr. Hall?
Yes, sir.
Okay. When you drove, when you drew on the map there, what was your field of fire?
So, do you want me to draw?
Yeah, why don't you draw your field of fire? What's your vantage point? What are you seeing? Do it in like a green or a different color. Is that within the scopes though? Your periphery?
Mm-hmm. It's not exactly to scale, but
Nothing further.
Ms. Long?
Thank you. First of all, you were hired in June of 2023.
yes, ma'am.
Okay, and after your hiring date, what did you do?
I was I was partnered with an FTO and was on field training officer.
I understand that, but did you go to DPSST?
Yes, ma'am.
For how long?
16 weeks.
16 weeks. So how long were you? June, July, August, September?
So I was employed under an FTEP program until October, and I graduated in March.
March of?
24, I believe.
So March of 2024 is when you graduated from DPSST, correct? And that's the Department
Of Public Safety Standards and Training, yes.
Okay, so you come back and you're under the supervision of a field training officer for how long?
I believe until June.
June of 2024. So you're on your own as a patrol deputy beginning July of 2024?
Sounds correct, yes.
So you have been, let's say, 73 days, right? About 73 days that you're on your own.
Sounds right.
Okay? 73 days as a deputy. Now, when I've got to put the microphone back on. Does this one work better?
It's really loud.
Mine's really quiet and yours is really loud. Oh, it is really loud.
Yeah, it moves.
You got me? Okay. So we saw States 1. When you pull up and you turn and you approach my client, now he's at a brick building, correct?
Yes.
And he's actually within basically a brick doorway, correct? And brick is a pretty good kind of safe place to be in regards to if bullets are coming.
Yes.
Yeah. And he's about, I'd say, between 20 and 30 feet from you, correct?
Probably a little less than that, maybe 15.
Okay. And just a little catty corner from that is a red vehicle. We see the back of it, and there's civilians there. Okay?
Just
and
sec.
then you have to say
Deputy
yes
Patterson,
or no.
can you do yes or no, just because the recording?
Yes, ma'am.
Thank you.
So just a few feet from where my client is are civilians near a red vehicle, correct?
Yes.
Okay, so just a few feet separate my client who's safely in a doorway of a brick building, correct?
Yes, ma'am.
And civilians exposed by a red vehicle, correct?
Yes, ma'am.
Okay. And you immediately go aggressively towards my client, correct?
No, I did not immediately go aggressively towards your client.
Okay. Well, did you see a different video than we saw?
No, but I was there before the recording started.
Okay, so but from what we saw, the evidence that we are looking at, you go up to my client, you tell him to leave his safe, what you just testified to was a safe spot, correct?
Behind brick, yes.
Okay, you tell him to leave that area, correct?
Yes.
Which would have put him in an unsafe area, correct?
No.
Well, let's back this up for a minute.
Okay.
Okay, Wells Fargo is here.
Yes, ma'am.
Okay, line of fire
Yes, ma'am.
we can agree that Philip Reese was in this Wells Fargo bank, correct?
If that was the name of the person inside the bank, then yes.
Okay, well, let me back up. The attempted bank robber was in Wells Fargo, correct?
Yes.
At that time, you did not know whether or not this person was armed, correct?
Correct.
What you did know, what you did testify to, that a line of fire from Wells Fargo, you drew it green, is right down this way, correct?
Correct.
And the red vehicle is like right here, correct?
Yeah.
Okay, would you mind if I marked it with pink?
No, go ahead.
So if my client is safely in an area right here, let's say in a brick doorway, correct? To leave that safety and go behind this red vehicle, he would have to expose himself, correct?
Yes, ma'am.
okay? And if a bullet was coming, he would be exposed to that bullet, correct?
Not with my engine block, the building on the corner, and then myself directly in front of him wearing a ballistic vest, then no.
Okay, okay. But you do agree that my client was in a safe place?
Safe for himself in the corner? Yes.
Thank you. Now, my client, and we saw in the video, reacted to you laying hands on him, correct?
Yes.
Okay. And he reacted to you putting a taser to his chest, correct?
Yes.
Okay, so would you agree that you accelerated the situation, correct?
Not with the taser, no.
Are you taught in your training experience to go 0 to 100?
A taser would not be 100.
Okay, but let's put this into perspective. You had a rifle, correct?
Correct.
You had a sidearm, correct?
Correct.
You had a taser, correct?
Correct.
You laid your hands on my client, correct?
Yes.
Okay. You removed him from the safe place that he was, correct?
From the place that he would have been safe from gunfire, yes.
Okay. And so you caused his reaction, correct?
I caused some of his reaction, yes.
Thank you. I have nothing further. Well, actually, I do have something further. I need my computer.
You need the plug?
I do need the plug. And feedback.
Why don't you just enter that?
Because I'm going to publish. Where do I put this?
You gotta have an online.
Are you guys squabbling?
What?
I was
You're
helping around
squabbling?
with the HDMI.
We're squabbling. Towards the end of the month. Trial months. Oh, I'm gonna go in.
It's not the USB, it has.
You hear me? I have it in.
You can scoot toward me, Deputy, if you'd like us.
Thank you.
I'm showing you what's been marked as Defendants 102. Did I move to enter?
102, no objection?
No, Your Honor.
102 is admitted?
And permission to publish?
Yes.
This is you, correct?
Yes, ma'am.
Okay. And when you became an officer, you swore to protect and serve, correct?
Yes, ma'am.
And do you protect and serve by turning your ring and then bringing your fist back?
I did not want to lose my ring.
You didn't want to lose your ring?
Correct.
Okay. Thank you. Thank you very much. I have nothing further.
You're welcome.
Redirect?
Oh, yes, sure. Deputy Patterson. Thank you. Deputy Patterson, how come you didn't use more force?
I was hesitant in using force.
You told him to move, didn't you?
I did.
And he didn't move?
Correct.
And then you told him again and he didn't move?
That is correct.
How many times did you tell him?
I'm unsure.
And then you went up and you, what, pushed chest like little third graders? Why didn't you just use force right off?
I did not feel comfortable using an amount of force. I just wanted him to move from the
Is that because you haven't been in law enforcement very long? You don't know how to do a job?
Objection, Your Honor.
Sustained?
Just curious why you didn't use appropriate force.
I did not want to manhandle him. I did not want to hurt him.
Well, why didn't you just pull a taser and not tase him?
And I did not want to hurt him. I did everything I could to try to stop him from receiving an injury from my actions.
Your Honor, nothing further, but I would like to mark as a demonstrative aid to this nice artwork that we've created.
What are we
Exhibit
calling
3.
it? 3? Do you object to 3 as a demonstrative exhibit? Exhibit 3 is admitted. Do you need a sticker?
I got it. 3
Okay.
sticker.
Are you done with questions?
Yes, sir.
Did you have anything else, Ms. Long? Anything else for Deputy Patterson?
No.
Thank you. You're good to go. Do you want him to remain in the hall or on call?
Did you release him?
She said she didn't.
I don't have anything further for him.
I'll release him as well.
Okay, you're good to go. Thank you.
Your Honor, may we have a quick break so I can
Sure.
use the
Let's
restroom?
take a little afternoon break, get some water, some coffee or something, and back.
Get in.
Okay, so we had a brief chambers. We talked about trying to just focus on what's relevant and not relevant. Ready for the next witness?
I am.
Defense ready? Ms. Long, you ready?
Yeah.
Okay, we'll get our jurors. You just hanging out watching us? Okay, that's fine. Just
Do you want me to talk with her? Do you talk with her?
Well, it shouldn't take long. When I go out, I'll just be like, hey, we're not
Okay, cool.
I mean, I think he's been around long enough. He'll follow.
Oh, I know. I know it'll take 2 seconds, but.
Well, I would hope.
oops. Yeah, mid-afternoon, need some coffee or something.
My dog just died, so I don't get it.
Okay, you can sit down. Next witness, please.
Need Sergeant Troy Jackson.
Come on forward around the table and stop and raise your right hand, please.
Under penalty of perjury, do you solemnly swear
swear or affirm that the evidence you give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Perfect. Come on up and have a seat.
Sorry if my voice goes.
That's all right. Those chairs are squishy. We need some chairs that let them fit. Please say your name, spell your last name.
It's Troy Jackson, Jackson.
Mr. Dietrich.
Good afternoon, Sergeant Jackson. How long you been an officer?
I've been with the Tillamook County Sheriff's Office 25 years with a couple of short breaks.
Okay. So this is all about the September 13th, 2024 around Wells Fargo, the bank. You aware of why you're here?
Yes.
Okay. Did you meet up with Mr. Hall, the defendant here?
Yes.
To discuss his version of what occurred?
Yes.
When was that?
Would have been September 26th, about 9, 10 in the morning.
Okay. And when you met him, did you get his side of the story?
Yes.
Okay. And what did he tell you?
Well, he told me a lot. You want me to?
Just about the incident.
He was at the Wells Fargo bank recording the bank robbery. He said he was behind police lines. He said he was under better cover than the deputy. Taking cover in the entryway to the CenturyLink building. Deputy Patterson had told him to move. We confirmed where the building was.
When he told you that he was confirming that Deputy Patterson had told him to move, did he give an explanation about why he didn't?
Yeah, I believe so. Because he said he had the legal right to be there, basically, and he was acting as a journalist.
Objection, Your Honor, relevance.
Sustained.
Besides that indication, did he have anything else to say about the incident?
So Deputy Patterson did tell him to move. He told Deputy Patterson he was in a safe place.
Did you have any discussions about when the scuffle started?
Yeah, he told Deputy Patterson he was in a safe place. And I'm quoting, he said, then Deputy Patterson went apeshit on me. He grabbed Hall and started to forcibly move him. Deputy Patterson cocked his fist back at me like he was going to punch me, grabbed Hall by both arms, twisted and turned Hall and was cussing at him. Hall asked Deputy Patterson to identify himself, and Hall was pushed and stumbled back behind the vehicle. Deputy Patterson grabbed him and said he was under arrest. He asked Deputy Patterson why he was under arrest. Told him for interference. Mr. Hall said interfering with what? He said Deputy Patterson then pulled out his taser, held it to his chest. Mr. Hall said he had a heart condition, and then Trooper Hughes arrived.
Did he mention anything about? So you just testified that he heard Deputy Patterson tell him to move. Did he say why he refused to move?
He said he was under better cover than the deputy.
Do you object to that answer?
No.
Okay.
Well, nothing further.
Ms. Long?
Just to clarify, when my client said that he told Deputy Patterson that he had a heart condition and problems and it wouldn't be good to be tased, correct?
Yes.
And when you met with my client, did he appeared to suffer from any health issues when you saw him?
Yes.
He was sitting in his car and he was on oxygen, correct?
Yes.
And he had a nasal.
He had a nasal cannula, yeah.
Okay. And my client was really upset when he was talking to you about being roughed up, correct?
Yeah, I think he was a little upset.
Nothing further.
Redirect?
No.
Thank you. I think he wants you to stand call, though.
Okay.
Okay. Next witness.
With Trooper Jace Hughesby.
You see him out there? Will you send him in, Sergeant?
Yes, ma'am.
Hugh. Good afternoon. Come on, you're right. Stop and raise your right hand. You snuck in.
Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this matter be the truth, the whole truth, and nothing but the truth?
Come on up and have a seat, and you can just move the chair forward or back. Say your name, spell your last name only.
My name is Jace Hughesby. My last name is spelled Huseby.
Mr. Dietrich.
Hey. Good afternoon, Trooper Hughesby.
Afternoon.
You were at the Wells Fargo bank robbery situation on September 13th of 2024, is that correct?
Yes.
And what was your role there?
So when I arrived on scene, I assisted with traffic control, same security, and then I later helped with making entry into the bank.
Okay, and I guess right when you were about to make entry, I guess you had to go and assist a deputy, Travis Patterson, is that correct?
Yes.
And I guess you had some body cam that you were wearing during that incident?
Yes.
This is going to be States Exhibit 4.
Any objection to States 4?
No.
That's admitted and you can publish. And Trooper, you can scoot toward me because it's up above your head. Don't mind blocking me.
Yeah.
No. I don't see him. Okay. Okay. So what, are we going in or are we waiting for SWAT? Okay. Okay, should we have Patty move up? No? Okay. Well, okay. 10. He got hands on him.
11, I need cover.
Travis, let it go. Let it go. I'm behind the police. Let it go. He's Travis, by the way. Keep behind the truck. Yeah, I'll draw fully.
We're not getting anything from Tillamook County, so you can monitor it. So I need one of you to either advise via radio or put comments in the call for 9 or 10. We're going to be making entries. We're going to be making entrances. Call from 7.
Get on the ground now! Oh.
Before you got the call there, I guess over the radio, and you heard the scuffling, what were you guys about to do?
Are you talking like before?
You started running back towards Deputy Patterson's position.
What were we going to do after that?
No, what were you?
It's irrelevance, Your Honor.
Overruled. What they were going to do prior to him running to
Yes,
back up Deputy
that-
Patterson. What was the plan?
I think it was just to make entry into the bank.
Okay.
I think I'm understanding your question.
Yes, that was my question.
Okay.
And so when you ran back, did entry have to be delayed?
I would believe so.
All right. When you got back there, exactly what was the situation with Patterson and him? You had him immediately go to his truck and stand guard again.
You talk about, okay, so when I ran over to help Deputy Patterson after he called for cover, what was my role?
Yeah.
Just based on what I had observed, I just told him to let it go, and then I ran back to my post.
Okay. How come you didn't assist him in executing an arrest real quick and then going back?
From my perspective, only my perspective of what I had observed, I didn't believe that Jeff was doing anything illegal.
You weren't back in that area, though?
No, I was up at the bank.
Were you aware of, at the time, what Deputy Patterson was instructing him to do?
I believe from what I had heard was he was telling him to get back or something along those lines.
Okay. But you weren't aware of what was happening in the back?
Objection, Your Honor, leading.
Sustained.
Leading where? Were you aware of what was happening in the back when you were up near the bank?
I had heard the commotion.
Right. And then you went back there.
Yes.
And you said, based off of what you knew, for him to go back to his post, then you went back.
Mm-hmm.
So were you aware of the discussion going on back there of Deputy Patterson asking him to move?
Like I said, I had heard him tell him to get back, and then I, saw that Patterson had put hands on him and then called for cover, and then I went to help.
Okay. Nothing further.
Ms. Long?
Thank you. I have just a couple, Trooper. When you arrived, you saw that Deputy Patterson had my client pressed up against a vehicle with a taser pressed against my client's chest, correct?
Yes.
And you told Deputy Patterson to let go because you didn't think Hall was committing a crime, but you just thought that my client was being an annoyance, correct?
Yes.
Thank you. Nothing further.
Any redirect?
I'd move to strike the officer's opinion as to what the law is.
I don't think overruled. He didn't say what the law was.
You didn't think he was committing a crime?
No, I didn't think he was committing a crime.
So have you ever had to tell someone to move?
Objection, Your Honor.
I can impeach my own witness.
Overruled.
Have I ever instructed somebody to move?
Yeah. Tell me to move.
I've told people to move, yes.
And when they don't, what do you do?
I don't think I've had anybody tell me no.
Okay. So ask me to move, and I'll tell you no.
Objection, Your Honor.
Move.
The basis?
Well, I mean, he's argumentative.
Sustained.
Okay, let's say you have someone that says no, and you believe that there's a safety risk.
I'm going to object, Your Honor. What's the relevance of this?
Overruled. It goes to it came in his opinion that he hadn't committed a crime. He's allowed to explore it.
Okay. I'm going to try to answer your question, but I'm trying to answer it in a way that makes sense to me.
Mm-hmm.
So, for instance, on a traffic stop, sometimes there's this thing called a reasonable arc of movement. Okay. Usually at the end of the first contact with somebody, we will say, "Please stay in the car." Now, if they get out of the car, I don't have anything to shove them back into the car. I might tell them to get back in the car, and they might. But as far as me putting my hands on them and forcing them back in their vehicle or placing them under arrest, that wouldn't work.
What do you mean it wouldn't work?
It wouldn't be justified.
Okay. If there was a public situation where you thought someone could be in harm or you had concerns about their location and you told them to move, you would never actually make them move.
I might explain to them the situation and why it would be a bad idea to stand there. But I don't know if yeah.
What if they were standing in a crime zone, like a crime scene?
I don't really know how to answer your question.
If someone was standing in a crime scene and you gave them a lawful order to move and they didn't, you wouldn't do anything.
I would probably ask a more senior officer.
And if that senior officer physically made a move, you would think that was wrong.
I think it's just based on the totality of the circumstances.
Okay, from your perspective.
Yeah, I don't know how to answer your question.
I know you don't. Thank you.
Are we done?
I just have one follow-up question.
Okay.
Mr. Trooper, when you arrived on this scene, did it appear that Deputy Patterson had really amped up the situation?
I think, I'm not exactly sure like the timing of when I arrived and Deputy Patterson arrived, because I parked my car over at, like, I think it was by 3rd and Main, and Patterson was over by 4th and Main. But yeah, it was just kind of like, I started hearing yelling coming from behind me at an odd time.
And the person who had hands on another person in a taser, that was Deputy Patterson in control of my client, correct?
Yes.
Thank you. Nothing further.
No.
Thank you. Is he released?
Yes.
Okay. You're good to go. Next witness.
I'm going to ask for a 15-minute break, Your Honor.
Okay, it's your second afternoon break. It's kind of like the hobbits get second breakfast. You get second afternoon break. Thank you. Please don't talk about the case. You can head on back.
We're going to go ahead and do our last witness, Your Honor.
Okay. Everyone ready? Okay. Yes. Okay. Next witness.
Patricia Archambault.
Ms. Archambault, come on up. Come on up and around the side of the table. And then look at the clerks and raise your right hand.
Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this matter be the truth, the whole truth, and nothing but the truth?
And then come on up to the witness stand. You can just move the chair back and then move the mic forward or back. Okay. Can you say your name, spell your last name only?
Patricia Archambault, Archambault.
Mr. Dietrich.
I apologize if I messed that up. Good afternoon, Miss Archambault. Archambault?
Archambault.
Archambault. Were you around for that, I guess, bank robbery in 2024?
Yes.
Where were you when that was happening?
I had just gotten off for work and walked over toward the Safeway store to kind of look to see what was going on.
Okay. And what was going on?
Well, at that time, it was pretty quiet. There was several people standing around, and the officer that was standing there to keep people back was...
Okay. At any point, were you directed to stay back?
Yes.
Did you?
Yes.
Did you witness anything between a Mr. Hall and an officer?
Yes.
What did you witness?
The officer had asked him several times to step back like he did the rest of us, and he wouldn't, and he probably 4 or 5 times at least asked him to step back.
And what did this Mr. Hall gentleman say?
He informed the officer that he didn't have to because he was behind the police line.
Okay. And what happened next?
That's when the officer tried to physically get him to step back, and he was videoing the whole thing, and Mr. Hall was, and was resisting moving back like he'd been asked.
Okay. Is this all happening right at that opening of the little door at the CenturyLink building?
It was back of that, so west of that, but that's where Mr. Hall went to stand, saying he was safe standing in there.
Okay. What happened after that?
Basically, shortly after that is when the camera was turned toward me by Mr. Hall, and he wanted to know what my name was because he was going to have
Objection,
me.
Your Honor, relevance.
What the defendant asked her.
Sustained. Let's move on.
Okay. Did you see any resistance by Mr. Hall?
Yes.
What specifically did you see?
Basically, he was just pushing back against the officer.
Okay. How long was he pushing back?
Probably 5-10 minutes.
Was Deputy Patterson using any aggressive, forceful means on Mr. Hall?
Objection, Your Honor, leading.
You rephrase into non-leading.
Did the officer apply any force?
Other than trying to move the gentleman back, there wasn't anything violently physical.
When you were instructed to leave that area that Mr. Hall was standing in as well, right? Why did you leave?
Objection, Your Honor, relevance.
Sustained.
Do you know that little corner we're talking about
Yes.
with the brick?
Yes.
Did you feel that was a safe spot for yourself to be in?
Objection, Your Honor, relevance.
Sustained.
From where you were at, was there a direct line to Wells Fargo
Yes.
that went into that little crevice?
I would think so, yes.
When you were standing there from that perspective, did you feel like that was within a line of fire from anyone at the bank?
Objection, Your Honor, relevance.
Overruled? You can answer.
I would have thought it could have been, yes.
And is that location where you're judging from where you were standing the same as where Mr. Hall was standing?
No, because I was back behind the vehicles that the officer asked us to move back to.
Okay. Did the defendant say anything else to you?
Other than asking for my name?
Objection, Your Honor, relevance.
Sustained.
All right. Thank you. Nothing further.
Just a sec, Ms. Long.
Yes, thank you. Ms. Archambault, is that right? Archambault? I tried to write it phonetically, so I remember. I just want to clarify, you were behind the vehicle, and which wasn't very far from basically the doorway in the brick building, correct?
Probably a quarter of a block away from it, yes.
So I'm confused because we watched video and it showed you kind of like you were behind the red vehicle, is that correct?
Well, it was a pickup that he asked us to step behind, yes.
Okay. And that was very close to where my client was?
Well, I would say the back of that pickup was lined up to the west side of the building where it ends.
Okay. And you were present when Deputy Patterson put a taser to my client's chest?
I didn't see a taser.
And the vehicle that you went behind, the pickup truck, was behind Deputy Patterson's patrol vehicle?
Yes.
Okay. Thank you. Nothing further.
Anything else?
No.
Is she excused?
Yes.
Do you object?
No.
Okay, thank you. Mr. Dietrich, anything else?
Nope. State's going to move to rest.
Okay. Your Honor, I have a matter for the court.
Guess what? Please don't talk about the case. Yeah. Ms. Long.
Thank you, Your Honor. This time, I move for a judgment of acquittal. Looking to the information, what the state has alleged and what they have to prove is that my client unlawfully and knowingly refused to obey a lawful order of Deputy Patterson, and that this order was to move to a safer location during a bank robbery. I think it's undisputed that at the time on September 13th, 2024, there was a bank robbery. What the state has failed to prove, even in the light most favorable to them, is that moving to another area was going to be a safer location during a bank robbery. Who they have relied on is Deputy Travis Patterson, who testified that my client was in basically this brick doorway. He testified that it was safe, that a brick would stop a bullet, that it was, just mere feet from where the other people were behind a car, that it would there would be exposure if he were to leave that area and go in to behind this other vehicle. Now, the other issue that we have here is, so I don't think that they get past that. Because if you look at the videos and you look at what is happening through the state's evidence, and is this basically my client's standing in this brick doorway with his phone. Deputy Patterson comes after him, initiates contact. My client refuses, which he can do, and the deputy is telling him to move. On the stand, he doesn't provide evidence that for him to move to a different place is going to be safer during a bank robbery. Basically, what the evidence is that Deputy Patterson just wants him to move and doesn't articulate here on the stand, why is that safer? Why is that going to be safer? And that is a component to this. We also have raised and put the state on notice that we've raised the issue of passive resistance. And I'm going to sit at this point just so I can pull up some case law here. We have the state versus Bracken, which is 341 OR App 318. It's a 2025 case. And in this case, let me pull up here. I think, first I want to preface this with, in the video, Deputy Patterson keeps saying, you're resisting, you're resisting, you're resisting. This is not a resisting arrest case. Passive resistance is not a defense in resisting arrest. It is an interfering with a peace officer. Now, in Bracken, in that case, the defendant appealed for a judgment of conviction. There was both resisting arrest and interfering with a peace officer. On appeal, the defendant argued that the trial court erred in denying its motion for a judgment of acquittal because he was engaged in passive resistance, which is not punishable under the statute, and the court erred by declining his passive resistance instruction. So in that case, the cops show up at this bar. The defendant was drunk, and you can't be serving drinks if you're drunk in an OLCC establishment. Basically, he's given directions by law enforcement. Given directions by the officer, he refuses. The officers basically say, get back here. He shakes his head. He says no. They say, you're under arrest. Then it lifts his arm, pulls himself away. He gets grabbed. There's a struggle both outside and inside into the parking lot where the officer forces the defendant to the ground and handcuffs him. Now, at trial, the defendant argued that he had engaged in passive resistance and acted in self-defense. And he argued that passive resistance was a defense to interfering with the peace officer, and that the use of physical force in response to Wetzel's arrest was reasonable because Wetzel applied more force than necessary. The court denied the motion for judgment of acquittal, and ultimately that was reversed. So what we have here is similar, and there's also another case it is State v. McNally. We have my client reacting to an overzealous deputy. He's the first one to put hands on my client. He raises his fist, makes sure to turn his ring because he doesn't want to lose his ring. He puts a taser on him. He grabs him. He's moving his arms, his hands. Everything, any physical response is a response to the initiator, Deputy Patterson. So I don't think they get past that threshold either. And I would ask for a judgment of acquittal, Your Honor. Thank you.
Thank you. Mr. Dietrich?
As far as the passive resistance, Your Honor, I think there's evidence in it as far as, because there was a lot of back and forth between resisting an arrest and the interfering. The case law shows you can't actually convict separately for those offenses because they're kind of tied together. So even if you were to charge two, one would go away. And in this case, it's a matter of passive resistance, and I believe it's been mentioned. We have okay. So yeah, passive resistance means non-cooperation for any reason with lawful order of peace officer in manner that does not involve violence or active measures. And that's from, as this defense has stated, State v. McNally, and there's some follow-up with it in State v. Washington and State v. Bledsoe. I think the difference here is once the officer is actively taking him away from that spot where at the time he did not believe was safe for him to be at, that the defendant here is actively resisting. He's pushing back. We heard not just law enforcement, but we heard from Patricia Archam. Sorry, you know the name. And she was even testifying that, you know, the defendant wasn't necessarily being passive. It wasn't a civil rights, like, I'm just passively resisting and standing here. He's actively pushing back, and he's being aggressive. And you heard Deputy Patterson provide that. And, you know, the cross-examination aspect of Deputy Patterson, if anything, just shows how confused the defense got on the cross. If you watch the body cam footage, that speaks out, and that's evidence. It's probably more on par than Deputy Patterson, who's never been on the stand before. Yes, if you go all the way behind the wall, and you're way there, you're in a safe location. But you can watch from the body cam angles, especially on Patterson's. He's hanging out. He's not in the thing. His arm is out, his camera's there, his body's fully exposed in a direct location to the bank. And then that goes, when you watch the body cam, it goes right into half that doorway. And so the key here really is when it comes to a lawful order, you could say, well, I personally feel this is a safer location. However, I just wanted to get this one. There's that case here. Yeah, this is that State v. Ruggles case there. To commit the crime of interfering with a peace officer, a person does not need to have culpable mental state with respect to the lawfulness of the police order. So on this particular case, the evidence demonstrates that Patterson had some concerns about the safety of that location, was asking everyone else to leave, and they did. One didn't. He went to try to get the person to go to where he thought was a safe location. He testified, well, no, it was a safe location. I was there in front of it. My pickup was there as well. And then this is a couple of cars back. That's where I want people. And as he's testified that way, in his mind, that's the safe location he wants. And the passivity resistance argument kind of falls because at some point, a deputy's going to have to do something. I mean, because, hey, don't stand there. And then the person says, no, I'm going to. And then the person decides, I'm just going to walk into the bank. No, don't do that. Well, you can't do anything because I'm just passively resisting. At what point do you draw the line? The person is giving the commands who has the responsibility of that sector, of that fire cover, and he's asking, and all these other citizens are lawfully cooperating and respecting officers, and then the defendant's refusing. And so, of course it's going to escalate. I'm going to have to make you move then. And then that's where it's no longer passive resistance. He's actively pushing back. He's throwing them. I've heard the testimony, Your Honor. So I think that's how the state would respond to both of those motions. I thank you for your time.
And Your Honor, I would just want to make a couple other points. First of all, any words by my client are free speech. And then also I would say that the state's own evidence contradicts their arguments, because the people that were behind this truck or whatever, there wasn't a separate officer there making sure that they weren't moving. Deputy Patterson's back was towards them. From the state's own evidence, they were free to wander, free to walk around, whatever. There was no indication that they were any safer than my client was. And the state's own star witness said that he was safe where he was.
So clearly an officer has the authority to ask a citizen during an active bank robbery to move to a safe location. I mean, I don't think there's any dispute that that is a permissible thing and a lawful order. The dispute is that was where Deputy Patterson wanted Mr. Hall to move, safer or not. Was it less safe or more safe? And I don't know. I mean, the officer thought it was more safe. There's certainly, that's why he asked him to move. According to Ms. Archambault, there were several requests to move, and it's unclear completely where exactly Mr. Hall was, if he was always back in the alcove. In the pictures, he was sort of sticking out of the alcove. So even if he wasn't completely tucked back there, I think that's a factual question for the jury. So I think that's enough to get to the jury, and they can decide that. Passive resistance. He tells Mr. Hall to move. Mr. Hall doesn't want to move, thinks he's better where he's at. Meanwhile, the officer's trying to deal with a bank robbery where they're about to breach the bank. And he's getting into a dispute with Mr. Hall about moving or not moving. He tries to then make Mr. Hall move. Mr. Hall doesn't want to move. So he's pushing on Mr. Hall. Mr. Hall's pushing back at him. He's trying to cuff him. Mr. Hall doesn't want to be cuffed. Understandably, he doesn't want to be cuffed. So then he's pushing back and not letting the officer cuff him. And this is all in the video. Then it escalates to the point where the deputy was looking like he was going to raise a fist to Mr. Hall. He obviously didn't punch Mr. Hall. Nobody's saying he punched Mr. Hall. He drew a taser, but he didn't tase Mr. Hall. And they're at that sort of escalated point when the trooper who's trying to, hears the escalation, you can hear the yelling on the trooper's body cam, has to stop what they're doing, trying to deal with the bank robber, to run over, to basically tell Deputy Patterson, Travis Patterson, to just let it be and we need to deal with the bank. And he does. So I think it's enough for a jury to make a decision. I'll deny the motion. Not that those aren't all valid points, but I'll let a jury figure that out. So is the defense presenting evidence?
No, except for what we've already submitted.
Okay. So I did propose instructions. I guess I do need to alter.
And I have a couple.
I do need to change 1021 Because I'd forgotten we had a defense exhibit. So, actually, can I have you fix this since I'm dealing with it? Just take off that paragraph. Thank you. Okay, have you guys had a chance to look at the instructions or not?
I don't have all of the instructions. I don't have a 1021.
Should.
I do.
Maybe it's just you that don't have it.
I have 1005, 1006B, 1025, 1008, 1006, 1024.
That's the defendant not testifying.
I was just taking out absolute right not to present any evidence because there I
Oh, wait,
forgot.
maybe I do under here. Yeah, I do. Never mind. Your Honor, in 1036, safer is misspelled.
No, I just copied Mr. Dietrich. He couldn't spell safer.
What? What'd I do wrong? Hold on. I've never been good with spelling.
1036? Safer's right. Oh, it's Safter. Oops.
That's Welsh. I go back to my native language.
Okay, so we will, one of them needs to be safer.
And in interfering with a peace officer, parole, and probation officer, I know that we have it in the knowingly and with knowledge, but I would ask that in section 2 would be Jeffrey Hall knowingly refused to obey a lawful order and
Okay, just a sec.
parenthetically to move to a safer place.
Oh, I need to get to the instruction.
Okay, just a sec, me too. So I fixed the 1021 to just, we're fixing this after to safer. So you're on 1240, Ms. Long?
I'm on 1240.
Okay, what are you asking to change it to?
I want parenthetically to be Jeffrey Hall knowingly refused to obey a lawful order and then put parenthetically to move to a safer place by the peace officer. I know that you have it in the knowledge, knowing and with knowledge, but I'm asking it to be placed there too.
So you wanted to mirror the information to say a lawful order to move to a safer location during a bank robbery to mirror the information?
Correct.
Mr. Dietrich?
You know, on this one, I'm not sure if that's needed, Your Honor. We put it in there kind of like as superfluous language, kind of like you do with to it. I think the elements that are required is simply a lawful order. I think that would simply be an attack to say they're actually wanting us to go to a location that was less safe, therefore it wasn't lawful. I don't think adding the language is in the elements of the actual statute, and I think its use in the information is superfluous, similarly to when we use to wit frequently. So I think the instruction's fine the way it is.
From the way the state has it, is the issue of whether it was a lawful order a question of fact or of law?
And I would, you know, I know.
In other words, is the jury deciding if it was a lawful order, or would that have been a question of law for me?
I can grab that.
And I think at this point.
It says, some case law, Your Honor. Lawful order is not unconstitutionally vague, Stavy Andre. Prohibition against refusing to obey lawful order is not facially overbroad. Let's see here.
I'm just wondering, who do you think decides if it's a lawful order? Are the jurors deciding if it's a lawful order? Because if it's not a jury question, then that extra language is superfluous. If the jury's deciding whether it's a lawful order, then the language to move to a safe location during a bank robbery seems like it should be in there. Ms. Long, your position?
Well, I would argue to that point, though, Your Honor, unless Ms. Long's ready, that it looks like State v. Ruggles might be the case to look at. That one states to commit crime of interfering with peace officer or parole or probation officer, person does not need to have culpable mental state with respect to lawfulness of police order, if that sheds any light.
So they don't need to know whether or not it was a lawful order, is what you're saying that case is saying. That they don't have to have a culpable mental state for the lawfulness prong.
I think I know the case here.
My computer's being slow. You're gonna have to restart it.
I'm sorry, what, Ms. Long?
I said my computer's being slow. I have to
Okay.
restart it.
So clearly he has to know he's a peace officer. We all agree about that. And he has to knowingly refuse
A lawful order.
a lawful order, meaning it seems like whether or not it was a lawful order would be a jury question.
Right. Because it's not just refuse an order.
Right. And if the jury's deciding if it was a lawful order, then I think we should put in the language what the order was, because how else would they determine? And I would note that the knowingly instruction that has it, the language in it was a state's instruction, the verbiage.
I think the courts decide if what is a lawful order when it comes to interfering with a peace officer and failing to obey a police officer.
And that'd be the jury.
No, the courts decide. Didn't even really think about this before.
Loading, loading, loading.
Should we go off the record?
With your Dietrich. And how many has the 30 granted restriction?
Yes.
Liz. Lawfulness of an order as a defense, the state retains the burden of proving the element and disproving the defense beyond a reasonable doubt, and that's side L.
That was in Ruggles?
So this,
We're doing this off the record. If we just want to have a discussion, that's fine.
I'm just showing my Westlaw.
Okay, so off the record, we've all been sort of researching this question of, does a jury decide whether an order is lawful if it's challenged or not? If a jury didn't decide that would be a question of law for the court, then what the order is would seem to be irrelevant. In other words, whether to move to a safer location. If I'm deciding that, then the jury's not deciding that. But then Ms. Long had a case that she found, which was what again, Ms. Long?
Your Honor, the case is State v. Seidel or Seidel. It's 294 ORF 389 218 from 2018. It says, however, when a defendant raises the lawfulness of an order as a defense, the state retains the burden of proving the element and disproving the defense beyond a reasonable doubt.
Okay, so state agreed that seemed like the law. So what that means then is the language that's in the information about what the order was, i.e. to move to a safer location during a bank robbery, should be inserted. So I'm having the clerk put that language. It was already in the knowingly with knowledge that was submitted by the state, so we don't need to alter that, but we are altering the to convict to include that language. So on a separate note, Mr. Hall, do you understand you do have a right to testify if you wish to do so?
Yes.
And is it your choice after discussing this with your attorney to waive that right and to remain silent?
Yes.
Okay. So We're almost done with instructions. We'll have the jury come out. I will read instructions. Were there exceptions to the instructions by the state?
No.
No, Your Honor, I just
Or
need
the
to
defense?
go to the restroom before we start.
Okay, so why don't we go off the record? Everyone can use the restroom that wants to use the.
Okay.
Or,
Well, just close. I'll just rest.
okay, you could just rest. That's probably simpler. Okay.
Do you want to grab this?
Okay, so we're on the record. You have an amended 1240. Any exceptions to that? That was the one where I added the language.
No. I don't.
Okay, so any other exceptions to this court's instructions?
Nope.
State?
And they still have the old 1240.
You want to read mine?
Oh.
Just
I
gave
got
you
the
the new.
updated. Yeah, there is. I just still have the older one in there.
Okay. So any exceptions from the state?
No.
Okay, we'll get our jury.
You got your mic?
That thing.
Ms. Long?
Your Honor, at this time, defense rests.
Okay. So what that means is you've heard the evidence. The next step in the process is for me to read you the jury instructions. You'll have these when you go into the back room. You certainly can take notes, but you'll have what I'm reading with you. It is your sole responsibility to make all the decisions about the facts in this case. You must evaluate the evidence to determine how reliable or how believable that evidence is. When you reach your decision about the facts, you must then apply the legal rules to those facts and reach your verdict. Remember, however, that your power to reach a verdict is not arbitrary. When I tell you what the law is on a particular subject, or tell you how to evaluate certain evidence, you must follow these instructions. Do not allow anything I have said or done during the course of this trial to suggest that I have formed any opinion about this case. Keep in mind that a judge is required by law to give certain instructions in every criminal case. When I have sustained objections to evidence or ordered that evidence be stricken or excluded from your consideration, you must follow these rulings. Do not consider such matters during your deliberations. Base your verdict on the evidence in these instructions. The lawyer's statements and arguments are not evidence. If your recollection of the evidence is different from the lawyer's recollection, you must rely on your own memory. In deciding this case, you are to consider all the evidence you find worthy of belief. It is your duty to weigh the evidence calmly and dispassionately and to decide this case on its merits. Do not decide this case on guesswork, conjecture, or speculation. You should make every effort to be aware of your biases including unconscious biases, and what effect those may have on your decision-making. In your deliberations, you must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we may not be fully aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision-making. Do not consider what sentence the court might impose if you find the defendant guilty. Generally, the testimony of any witness whom you believe is sufficient to prove any fact in dispute. You are not simply to count the witnesses, but you are to weigh the evidence. Keep in mind that each party is entitled to the considered decision of each juror. Therefore, you should not give undue weight to another juror's notes or memory if they conflict with your recollection of the evidence. The court has provided written instructions for your use. When you use these instructions, do not place undue emphasis on any particular instruction, but rather view the instructions as a whole. During the trial, the court may have received evidence in a modified form. This evidence may have been edited because it contained irrelevant or otherwise inadmissible material. If you notice or suspect that evidence has been modified, you are not to speculate about the substance of what may have been removed or modified, or why it was modified. You should not consider evidence to be of greater or lesser evidentiary value based solely on the fact that it has been modified. There are two types of evidence. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, the proof of a chain of circumstances pointing to the existence or non-existence of a certain fact. You may base your verdict on direct evidence, or on circumstantial evidence, or on both. In deciding this case, you may draw inferences and reach conclusions from the evidence, if your inferences and conclusions are reasonable and are based on your common sense and experience. The term witness includes every person who has testified under oath in this case. Every witness has taken an oath to tell the truth. In evaluating each witness's testimony, however, you may consider such things as the manner in which the witness testifies, the nature or quality of the witness's testimony, evidence that contradicts the testimony of the witness, evidence concerning the bias, motives, or interest of the witness. When a witness testifies about statements made by the defendant, you should consider such testimony with caution. In reviewing such testimony, you should consider, among other things, the following. Did the defendant make the statement? And if so, did he clearly express what he intended to say? Did the witness correctly hear and understand what the defendant said? Did the witness correctly remember and relate what the defendant said? Did the witness intentionally or mistakenly alter some of the defendant's words, thereby changing the meaning of what was actually said? If after weighing such factors you conclude that the defendant said what he intended to say, and that the witness to the statement correctly understood, remembered, and related to you what the defendant said, then you are authorized to consider such statements for what you deem them to be worth. A person commits the crime of interfering with a peace officer if the person, knowing that another person is a peace officer, just a minute. knowingly refuses to obey a lawful order by the peace officer. To establish the crime of interfering with a peace officer, the state must prove beyond a reasonable doubt the following elements. The act occurred on or about September 13th of 2024. Jeffrey Hall knowingly refused to obey a lawful order by the peace officer to move to a safer location during a bank robbery, and Jeffrey Hall knew that Deputy Patterson was a peace officer. A person acts knowingly or with knowledge if that person acts with an awareness that a particular circumstance exists. When used in the phrase, knowingly refused to obey a lawful order of Deputy Patterson, a person known by the defendant to be a peace officer, that order was to move to a safer location during a bank robbery. Knowingly or with knowledge means that the person acts with an awareness that there is a lawful order to move to a safer location. Knowledge is also established if a person acts intentionally. Peace officer, a member of the Oregon State Police, a sheriff, constable, marshal, municipal police officer, or reserve officer. The defense has raised the defense of passive resistance. Passive resistance refers to non-cooperation with the peace officer's arrest that does not involve violence or active measures, but can involve verbal refusals, whatever the motivation for the non-cooperation, and regardless of whether the non-cooperation takes the form of acts, techniques, or methods commonly associated with the civil rights movement. The state is required to prove beyond a reasonable doubt that defendant did not engage in passive resistance to his arrest. A defendant has an absolute constitutional right not to testify. Therefore, a defendant's decision not to testify cannot be considered as an indication of guilt, should not be commented on or in any way considered by you in your deliberations. The defendant is innocent unless and until the defendant is proven guilty beyond a reasonable doubt. The burden is on the state and the state alone to prove the guilt of the defendant beyond a reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt is not an imaginary doubt. Reasonable doubt means an honest uncertainty as to the guilt of the defendant. You must return a verdict of not guilty if, after careful and impartial consideration of all the evidence in the case, you are not convinced beyond a reasonable doubt that the defendant is guilty. Mr. Dietrich.
Thank you. One day, I think this was set for 2, so it's been pretty quick for trials as far as they go. I appreciate you guys sitting through all this and hearing the evidence. This is my chance for a closing argument where I can try to get an opportunity, unlike the opening where I kind of tell you what the facts of the state thinks they might come out, but argue the case a bit. So we had some stuff where we were discussing. You heard Deputy Patterson about protect to serve. And what does that mean? You say Deputy Patterson didn't have a lot of experience. I think that kind of came out. I think the evidence showed his heart's in the right place. He's in a position. And it's his job, as he elicited on the stand, not only public safety around, but what could be communicated to unknown individuals in the bank where his current understanding is there's a bank robbery. And you see a bunch of people in an area,
And so he asked them politely to leave, go back a little bit further, because remember, you can see it, you got those 2 patrol trucks on the street, and then back they have some other vehicles lined up. So he's like, just go back a little bit more behind one of these vehicles. And they do. We heard from, and I'm going to kill the name, Patricia Archambault, and she was talking about what she saw. We heard that testimony. And, you know, Deputy Patterson laid out his testimony on direct. It was pretty clear. Then you heard him on cross. It was pretty aggressive cross, where, oh, a brick isn't safe, and he's like, oh, it's safe. And suddenly the defense has created this idea that his initial ideas of why he's ordering people back were because he was just being arbitrary and capricious. He was just being, just because I want to. And kind of changes the narrative a little bit. But listen to and think about his direct testimony. I felt it was unsafe there. And as they mentioned, their duty is to protect and serve. So he's there trying to do his duty. And you can say, well, his order, it makes no sense. I disagree with it. But watch the body cam video, the video that you see. The defendant is in that little cubby hole that goes into like the door, but his whole body is basically sticking out. And he's recording. He's not behind a brick wall the entire time, because from this angle, when you look at it all, he has a direct line of sight to the bank doors right when they're about to breach. And as Deputy Patterson mentioned, he had the concerns that, who knows, that could be a live feed into the bank, showing when they're moving.
Objection, Your Honor. Assume staff's not in evidence.
Sustained.
What was the objection?
That he didn't say that.
Yeah, he did.
No, he didn't.
So, we have a situation where he gives an order. And we heard with Sergeant Jackson, the defendant is aware of the order. He acknowledges he knew what the order was. He simply wasn't going to follow it. So, what's the point in having the cop? What's his job? What if someone just walks into the intersection? Why not towards the bank, towards the doors? At what point does an officer's order become relevant at all? When everyone can simply say, I disagree with you. There's an active robbery of a bank, and I'm actually just going to go in that bank. And you're ordered not to. And so we do know, as it needs to be shown, we do know it occurred September 13th of 2024. And that he knowingly refused to obey the order, right? Because apparently there's going to be an argument that it wasn't lawful. And it wasn't lawful because he was in a safer location. But if he was in a safer location, then look at the body cam. He wasn't back in the door, out of sight, cover. He was not in cover or concealment. He had no cover or concealment. He's standing like this, directly towards that way. So, I guess you could say if there were gunshots that started to fire, you could move back. But the officer on scene made a decision. And we heard Trooper Hughes be like, I didn't think it was a big deal. Just go back to your thing, we're about to breach, right? Okay. So he would have done stuff different. But the person here is Deputy Patterson. And Deputy Patterson felt that that spot, he wanted him back further. And he asked numerous times. And he simply said, no. That's bad. What happens next? Well, Deputy Patterson thinks, I have to get this guy out of this spot. You're going over here. And now it's like, no, you're not. Now it's active. He's pushing, he's pushing. Now it's physical. Now voices are raised. Now there's tension. Now there's chaos. Now there's confusion. Now you have officers everywhere else wondering what's going on. All because one person didn't want to move. One person wanted to be the head of the show. Well, a serious matter is going on. And he has to take him. And you see the defense exhibit of this photo from a screenshot of the body cam we've watched. Taken out of context, it looks vicious. That's the body cam screenshot. Get the worst part of it. And you heard his testimony. So when people say whether or not Deputy Patterson should have just done nothing, it wasn't a big deal. At what point does it become a big deal? And who gets to make that decision? The person paid to protect and serve, or the citizens? Because if that's the case, we don't need cops. We can just figure it out ourselves. I think the evidence shows that it was September 13th, 2024. The defendant knew, and he refused to obey a lawful order to go back further behind more vehicles to a safer location. And he knew Deputy Patterson was a peace officer. He was next to a truck, you can see it. Has the lights, has the markings, he's in uniform. This was simply someone who didn't want to comply. And it wasn't on some miscellaneous stupid issue like trespassing or a cop being a jerk. It was a young cop, new on the force, probably his first bank robbery, adrenaline pumping, protecting to serve, wants to do his job. And he gets a heckler who wants to suddenly turn a serious situation into him. And I'm going to ask you to come back with a finding of guilt. Thank you.
Thank you, Ms. Long.
May it please the court, counsel?
You want this one? It's really loud. I'm not sure why they want this. Like a setting.
Got me? Who gets to decide? Not a bully in a uniform. You, the six of you. The six of you get to decide what happened on September 13th, 2024. Not an overzealous, angry sheriff's deputy who had 73 days of experience and too much aggression and too much power. That's not who gets to decide. That's you. And let me tell you, we all get to be annoying. We live in this country. We can take our phones and we can video the cop and they do not have the right to lay hands on us, to shoot us, to tase us, to cuff us. Deputy Patterson didn't have that right on the 13th in September of 2024. Why? Because he had not given a lawful order. Because let's make it really clear what we're not here about. My client's not charged with resisting arrest. He's charged with interfering with a peace officer. That means that the state has to prove beyond a reasonable doubt that my client refused the lawful order. And it's not just any order. It's the order that he refused to move to a safer place during a bank robbery. That's illusory. That is made up. That's not what Travis Patterson was ordering. He was ordering him to move, but not for my client's safety. He just wanted to disrupt him from videotaping him. Because think about it. Look at the evidence. You have the law enforcement. They are parked near this brick building. They have a pickup where civilians, more than one, are behind. Are those civilians secured? No. Are they being monitored? No, there's no evidence to that. Is there any evidence that anybody else in law enforcement is watching them to make sure that they don't just wander out into the road, that they continue up the road, that they go towards Wells Fargo Bank? No. Is that area safer than where my client was? No. My client is in a doorway in a brick building. Is that safe? Yes. Who told us that? Deputy Patterson. But he decides to flip the switch when my client didn't want to obey his order. Not a lawful order, just an order. And you have to make that distinction. Because the state has to prove beyond a reasonable doubt, not preponderance of the evidence, not clear and convincing evidence, beyond a reasonable doubt, beyond a moral certainty, that it was safer. Safer. They haven't shown that. Their own witness has testified that my client was safe where he was. You can refuse a law enforcement order. You can. I don't care what the state tells you. Deputy Patterson didn't like it. He doesn't like somebody refusing his order. Watch the body cam. Look at the evidence. Chief Deputy District Attorney acts like that screenshot is taken out of context. How can this be taken out of context when Deputy Patterson said he didn't want to lose his ring? He wanted a fight. That's what he wanted. Bullies like this want to bully. Put him in a uniform, give him a gun. That's what he wanted that day. And unfortunately, my client was exercising his right to be an American. You can hear it on the video. My client's not a quiet guy. But everything that he was doing was within his rights. His right to free speech. His right to be out in public, to congregate, to video somebody in law enforcement. Any physical action that he took against Deputy Patterson, as confirmed by Deputy Patterson, was in reaction to the deputy's aggression towards him. It would have kept on going if Trooper Hughesby hadn't stepped in. If Deputy Patterson was so concerned about this bank robbery, why didn't he de-escalate the situation? All he did was escalate it. Now, I'm not asking you to find my client not guilty because Deputy Patterson is a bully and a jerk. I'm asking you to find my client not guilty because that's the only just resolution, because the state has failed to prove beyond a reasonable doubt that my client was given a lawful order. They have also failed to prove beyond a reasonable doubt that my client's reactions to this aggressive deputy were anything more than passive resistance. And passive resistance can be more than verbal. It can be reactionary to what somebody else is doing to them. So I ask you again to return the only just verdict. Don't let this stand. Find my client not guilty. Thank you.
Thank you, Ms. Long. Final comments, Mr. Dietrich.
Yes, Your Honor, thank you. This is my chance just to rebut some stuff that came out. Concerning language there. Aggressive deputy, de-escalate the situation, a bully, he's a bully, a lot of character attacks, a lot of attacks. The only thing that Deputy Patterson is probably liable for is that he was a food. That's what we call someone who's new. Because any veteran often would have had the defendant on the ground in 20 seconds and would have had him in the back of their patrol car. It would have been done. No, Deputy Patterson's only mistake is he tried to de-escalate. He tried to talk with someone who you can't talk to, someone who you can't ration with, someone who you can't have a reasonable conversation with, someone who won't listen, someone who won't comply. No, a veteran officer, he would have calmly went over there, had him on the ground in 20 seconds, and he would have been in a vehicle. This would have been gone, done. His problem was he was too nervous.
Objection, Your Honor. Assumes facts, not evidence.
Overruled.
He was too nervous. He was trying to de-escalate. And where did it get him? 5 minutes of back and forth with someone he couldn't argue with or lodge with.
Don't resound.
All it got him was a breach that had to be delayed. So, the comments that he's the bully, that he's an aggressive deputy, I just don't see it. State sees someone that should have had him on the ground within 20 seconds. There was no reason for this. Going back to, what's your badge number? 211 Patterson. Why are you even talking to this person? Put him on the ground. Do your job. Control the situation. There's a bank robbery going on, and you're playing pity patty tomato whatever child game on the street with some guy trying to film stuff. He should have done his job. He should have done it aggressively. I wanted to point out, because that's a false narrative, that he's a bully that wants to bully people. He's a timid guy who didn't know how to handle someone who refused to leave 10 feet back. That's why we should never call someone like Patterson a bully. Thank you.
Thank you. When you return to the jury room, select one of your members to act as presiding juror. The presiding juror has no greater voting weight, but is to preside over your deliberations and be the spokesperson for the jury. You should then deliberate and find your verdict. If it becomes necessary during your deliberations to communicate with me, do so in writing. I will consult with the parties before responding. No one except for you, the jurors, is to be involved in your deliberations. Therefore, do not tell anyone, including me, how many of you are voting not guilty or guilty, until you have reached a lawful verdict or have been discharged. Each and every juror must agree on your verdict. So whether your verdict is guilty or not guilty, all of you must agree on this verdict. If you are divided 5-1, for example, you do not have a verdict. When you've arrived at a verdict, the presiding juror will complete and sign the appropriate verdict form. After you've reached your verdict, signal the bailiff. The court will then receive the verdict. And then obviously you have the verdict form with the obvious two choices, not guilty and guilty. Who's ever your foreperson can either initial or check your unanimous decision. After hearing the charge, the jury shall retire for deliberation. When they retire, they must be kept together in some convenient place under the charge of an officer until they agreed upon their verdict or are discharged by the court. Unless by order of the court, the officer must not suffer any communication to be made to them or make any personally, except to ask them if they agreed upon a verdict. And the officer must not, before their verdict is rendered, communicate to any person the state of their deliberation or their verdict is agreed on. I can barely see you guys behind it, but do you solemnly swear that in taking charge of this jury, you'll conduct yourself according to the provisions of this section of code, which I just read to you, that you're familiar with to the best of your ability, so help you God? Okay, perfect. So what that means is you now are going to go back to deliberate. You're going to have the jury instruction packet. If you wish to look at any of the evidence, that's the video evidence that's been admitted, let the clerks know and they can bring in the dinosaur laptop that we have for you to look at that. And thank you for your attention so far. So, Mr. Hall, I have no idea how long the verdict is. It could be 15 minutes, it could be 4 hours. So I need you to stay in the courthouse, please. You don't want to go out through the front doors because they'll lock behind you after 5. So you need to be somewhere sort of out in the lobby. We do lock the courtroom, though. So just somewhere out there.
Okay, but I need to be back in before 5.
Yeah, I think, yeah.
Okay, I'll be in.
If you need to step out and come back in before 5, that's fine, but at 5 is when the door's locked.
Okay.
Okay, thank you.
And then we the door there, so that you don't, there's no chance of running into jurors. So when you come back and we
Okay, so I need to, yeah, I need to step.
Yes, ma'am.
Are you Mr. Kowalski?
Yes.
Okay. So on the record on State versus Chase Kowalski, it's 23 CR 01991. In the courtroom is Miss Lyon. She's covering for Miss Long, who's covering for your attorney, Mr. Lyon, just today. The other person's Mr. Dietrich from the DA's office. So it looks like you have probation violation paperwork there, sir. Top left-hand corner is your name spelled correctly.
Yes, ma'am.
How about your date of birth? It's got 128 of 03 at the very top under your name.
Yes, it is.
Ms. Long.
Your Honor, I'll acknowledge receipt of the document, waive formal reading and advice of rights, reserve the right to move against the charging instrument at a later date, and ask that this be set over in normal course for Mr. Lyon.
So, Mr. Kowalski, release assistance is recommending against release. That's based on the allegations of failing to comply with probation. So it's going to be a no bail hold. Your next court date is next Monday at 8:30 in front of Judge Hill. Mr. Lyon will speak with you between now and then to go through what the allegations are and what your choices are at this point in time.
Okay, am I allowed to say something?
No.
It wouldn't really help. I mean, at this point, it's something to talk to Mr. Lyon about, and certainly it's something if you make admissions, you could talk to Judge Hill about.
Okay.
Okay, thank you, sir. That's it for now.
No. Thank you, though.
Tired. I don't know why I'm tired.
Because it's trial day. Yeah. It's exhausting.
So tomorrow I get to sit in my office and get one on the record list. Mr. Pickle, can you hear me?
Yeah.
Okay, so there's two case numbers, State versus John Pickle. It's 25 CR 70841 and 24 CN 04578. Mr. Lyons, still your lawyer. Ms. Long's in the courtroom. She's covering for today only. Mr. Dietrich's here from the DA's office. So you should have motions to revoke release. Top left-hand corner is your name spelled correctly.
Yeah.
How about your date of birth, sir?
Yeah.
Ms. Long.
Your Honor, I'll acknowledge receipt of the documents, waive formal reading and advice of rights, reserve the right to move against the charging instrument at a later date, and ask that these matters be set over in normal course.
So, Mr. Pickle, release assistance is recommending against release. Looks like you didn't follow through on your last release. So the older case is a probation violation, so that's a no bail hold. Your new case is a regular case, so that's $30,000, 10% of which could be posted. Your next court date's next Monday at 8:30 with Judge Hill. Mr. Lyon will come speak with you between now and then to go through what your choices are, etc. So that's it for now, and he'll come speak with you before your next court date. So thank you, sir. Okay, we're back on State versus Jeffrey Hall. File number 25CR08187. Everyone's here. Jury's reached a verdict. We did have one question a couple hours ago, two questions that the lawyers stipulated to the answers which are on the paper. It was about, anyway, it's on the papers. And the lawyers agreed that the answers were appropriate. Correct?
Correct.
Mr. Dietrich, yes?
Yes.
Okay, so we're going to bring in the jury. Mr. Hall, obviously I have no idea what the verdict is. When I actually have the paper in my hand, if you and your lawyer could please stand. And it's obviously inappropriate to have any kind of reaction, either positive or negative, okay? All right, we'll go ahead and get our jurors. Okay, juror 97, you look like foreperson, is that accurate? Yes. Could you hand that to Sandra, please? Yes. Thank you. It reads, we the jury find the defendant as to count 1 interfering with the peace officer guilty, and signed and dated. You can be seated. Was this a unanimous verdict? Does everyone agree? Everyone shaking their head yes? Everyone agrees it's unanimous verdict? Okay. What that means is you're done. It's been a long month. I want to thank you for all the time you put in on this tonight. So you're released. Sandra's going to give you your phones back. Have a nice evening. We're done with jury trials for the month, so you don't have to worry about calling in. And thank you very much for your service as jurors. Thank you. Do we need a sentencing date?
Do you want to be sentenced today, or do you want to come back?
I'll come back.
Okay.
Okay. So let's look. It looks like next Tuesday or next Monday.
I'm really booked up on.
Okay. So the Monday after that, the 9th. How about 3 o'clock on February 9th? Does that look okay, Liz? That's fine. February 9th at 3? Does that work for the state?
At 3.
Just a regular Monday afternoon here.
Does that work for you?
Okay, so Mr. Hall will get you a paper with that on it. We'll see you on that date, okay? No, just those two. Just those two.
Oh, good night, Your Honor.
Thank you, too.
Ms. Wall.
We're done?
Yeah, they're going to get you a paper, Mr. Hall, and then you're good to go.